Yes.
One of the substituted legal heir died, my lord, and we have filed Muqaddimah also today, my lord. It may come after 2 weeks, my lord. We can file that substitution.
Old matter, isn't it?
All matter, my lord, but only, my lord, after substitution, after 2 weeks, my lord, it can be disposed of.
36.
Yes. One of the substituted legal heir died, my lord.
Well, your new set of counsel.
New, my lord, new counsel. My lord, because earlier, my lord, counsel was elevated, my lord.
The other side?
Other side, my lord.
Okay, with some accommodation. Okay.
Yes.
Sri G.N. Sahewala Lalit Senior Counsel has submitted that he has been engaged newly for the petitioner. Full stop. He has also submitted that there are certain developments requiring substitution. Full stop. Para. And has accordingly prayed for adjournment. Para. Considering the above, comma, matter is adjourned by 2 weeks. Yes.
May it please your lordship.
Yes.
Well, I beg to mention for listing of a writ petition tomorrow, my lord.
Motion.
My motion, my lord.
Motion is tomorrow, yes. What is the urgency otherwise?
My lord, tender matter, my lord, 60 the last date.
Tender matter?
Yes, ma'am.
Tender bans for
That's for now.
Fine.
Sorry.
luckily we have asked the subject, otherwise. Yes.
Please, your lordship, I beg to mention a writ petition for listing, lordship. Lordship, it pertains to
New matter, fresh matter.
No, lordship. So,
Then old matter, which matter of which year?
lordship, 2025 only,
Why out of turn listing?
lordship, it ought to have been listed after.
That is not a good enough reason. You have to have urgency. Out of turn listing by mention memo is only for urgent matter. Sorry. Yes.
Beg to mention item number 34, lordship. I've taken consent from the other side, lordship. I may pray this matter may be taken up on Friday.
17B.
17B, lordship.
Why are you taking time? We came prepared with this matter.
Lordship, my senior, Mr. A.N. Chaudhary is, lordship, some personal
Okay.
difficulty. Friday, lordship.
Mr. Mazumdar has been informed.
Yes, lordship.
Friday we'll fix it, but we do not know whether how much. On a request made on behalf of the writ petitioner, on behalf request made by Sri S. Chakraborty Land Council for the petitioner, matter is adjourned to be listed on Friday next. Date, huh?
How like?
Interim order, there is an interim
No
order.
internal, lordship.
Lordship, may I please to mention that the matter is related to land acquisition.
Yes.
The petitioners have not.
What
been
do you
paid.
want, madam? You want listing?
Yes.
Listing of new matter or what? Admission matter of which year? Matter of which year? What is the year of the matter?
7.
2007?
It was last listed in 2025.
Matter of which? What is the number of the case?
8426 of 2022.
22 matter. What is the subject matter?
Compensation for land acquisition, which was acquired by the railways since 2007.
22 matter. Okay, Wednesday next. Not this, not tomorrow. Next Wednesday. Give the date.
Lordship, my senior will be out of station. So after 10, any
After?
10 of September.
Why are you mentioning now then? If you want after 10th of September. Today is only the 2nd. You make a mention in the next week. 22 matter, we may perhaps allow the mentioning. Make a mention on 8th. Next week we'll allow. Okay. Yes, Mr. Monto.
May I please? Item number 33, my lord. In this case, we could take steps on responsibility on
33 is a 17 matter.
lordship because of we engaged later on, my lord, and also due to communication gap, my lord, could not take step. We have taken step, my lord, on last week, my lord, and as per
If the clients are not interested to pursue,
now we could contact, my lord. So at least one chance, my lord, after services is completed, my lord.
let the matter reach. We like to see the matter. 17 matter for orders.
I will be in a record.
We will not know. You have to have some of your colleague here.
Lords.
Now, to look at the order of 13/8/2025, instructions, my lord, were sought for on the issue of, my lord, reclassification,
Yeah.
eco-sensitive zone, my lord.
I have received the instruction. It cannot be reclassified after the publication of 3A notification. And that apart,
It is an eco-sensitive zone.
eco-sensitive zone, certain activities are permissible,
Hmm.
but opening up of a petrol pump is not permissible.
My lord, the petrol pump we cannot open as of now because the land is already gone in highway acquisition. So
Hmm.
the frontage is gone.
Hmm.
So the petrol pump project, though we had permission at that point of
Hmm.
time, that project is not feasible as of
Hmm.
now. So
Now
that
what
we
do you
have, that
propose?
we have abandoned already.
Now what do you propose?
My lord, because it is not reclassified as of now, I cannot do anything in the land. I cannot even construct a house, my lord. Whereas all my vicinity is already commercial, my lord. The forest report, my lord, at page 26, my lord. It shows,
Yes, please.
it shows that I am surrounded by the Patiksha Nursing College, Maharishi High School, Tata Godown
Mr.
Industry and Lime Factory.
Talukdar, so far as the petrol pump project is concerned, he has said it is not now feasible.
They
Now
have-
he wants to have other structure. Is it possible?
Only because when after the publication of 3A notification, the classification, transfer of classification is not permissible. Because the value will increase.
When did you purchase?
My lord, the land is, my application of declassification is 2016, my lord.
And the vicinity areas, there are structures.
My lord, that's Patiksha Nursing College, Maharishi High School, Tata Godown Industry and Lime Factory. This is the boundary, my lord, of my land at page 26.
Cannot, you
Forest had given a
you
clearance.
cannot consider for
Certain activities are
for
permissible.
yes, those permissible for those permissible activities.
Yes,
We are not on having an industry or a petrol pump, which is maybe after the
Right.
3-year notification is not permissible. But there would be, since there are other
If
stuff.
some lands are left out,
What is the area of your land?
my lord, it is 2 bigha, 1 katha, 6 lesser.
Mr. Talukdar, put this on affidavit,
Lodge.
we'll try to sort it out, okay.
My lord. But
I
I
heard
also
some-
understand that the notification I have also annexed. Certain activities are prohibited,
We'll
certain
examine-
activities are,
we'll-
my lord, restricted,
Yes,
regulated in a way.
we'll examine that aspect. So far as prohibition is concerned, this, it may not be possible or it may not be feasible for this court to explore into that.
My
But
lord,
so far as activities which are regulated activities are concerned, we may, if you can make out a case, we may direct for consideration.
my lord.
Lordship, whether the entire land was acquired, that of course I do not have.
Heard Sri B. Pathak, learned counsel for the petition appellant. Pursuant to the order dated 13/8/2025, Sri B. J. Talukdar, learned additional senior governor advocate Assam, has placed before this court written instructions dated 1/9/2025. Full stop. It is submitted that a notification of eco-sensitive zone was issued
17/5.
on 17/5/2020
2000.
or 17/5 or 27/11.
No.
Or 7/5.
17/5.
7/5.
7/5/2017.
2017.
7/5/2017. Whereafter such reclassification, that too for a project like petrol pump is not permitted. Para? Sri Pathak, the learned counsel for the petitioner has responded that the proposed project of petrol pump has had to be abandoned. Full stop. However, there are certain other activities which comes under the regulated activities, which perhaps can be considered. Full stop. Para, let the state respondent file an affidavit based on the instructions dated 1/9/2025.
Twofold submission. The first is 7/5/2017. Second is after my lord 3A notification. That is
He has also submitted that after publication of the notification under section 3A of the National Highways Act 1956
On 17.
on 17/1/2024, the land in question has become part and parcel of the acquired land, correct?
Ma'am.
Acquired land. Then, state respondent to file an affidavit on the basis of the instructions. Such affidavit be filed within a period of 2 weeks from today. Let the affidavit come, we'll take a call.
Hello.
You kindly indicate whether the entire land has gone or what?
Area is shown
Um,
below.
in the,
the
when
notification
you
I
say
have
the
the-
affidavit, it has to be specifically stated as to the amount, as to the area of land which has been acquired. As to
The-
area of land, as to how much area of the land of the petitioner which has been acquired. Yes,
Deep blue. Date, any date, ma'am?
2 weeks,
1.12 bigha, my lord, is acquired.
okay, that has been acquired.
My lord, that's for the.
Out of two something, out of two.
As per the notification we have received from land acquisition.
Notification, I have the notification.
Can I get that
Possible-
notification also?
Hello.
It's an R. Deep blue.
In this matter, my lord, I, appear on behalf of Mr. Singh, my lord, learned senior counsel, my lord, I pray for some accommodation today.
What is the matter?
Matter regarding some dispute of mutation, my lord, regarding between the petitioner and the respondent, the private respondent, my lord. I'm not on record, my lord, in this.
No,
matter.
doesn't matter.
Your lordship, actually, they have been taking time for a long time. The senior.
We'll fix a date
Your lordship, probably at a, because an interlocutory application is also pending. Your
by
lordship.
you
Yes, your lordship.
for,
For your lordship, though there is no interim order in their favor, your lordship, but I am not being allowed to renovate my house, your lordship, because of the pendency.
okay, we fix Tuesday next.
No,
No further time.
Can it be on 23rd?
Your lordship, I won't be present after
20?
23rd, my lord, it's a hearing.
Why are you taking 23rd? Today is only the 2nd. We'll have it on 9th,
Yes, your lordship.
9th or 11th.
Your
Not
lordship.
11th, 11th is, will be difficult. 9th, I think.
Lordship.
Mr. Ganguly, 9th.
Lord,
3, E. Ganguly, Learned Counsel submits. Learned Counsel appearing on instruction of S.K. Singh, Learned Senior Counsel, prays for a little accommodation. Para. 3, your,
I Hussein.
I would say 3, I Hussein, Learned Counsel for respond number 4, has however submitted that on previous occasions also adjournment was sought for by the petitioner. And in spite of the fact that there is no interim order, comma, the respondent number 4 has been restrained from renovating his construction. Para. Be that as it may, while the matter is adjourned, the same is directed to be listed for admission hearing on 9/9/2025.
Oblige, your lordship.
Oblige. But in this matter, my lord, I have instruction that the loan account in question has been settled by the private respondents, my lord, with the bank. I am not the borrower, my lord.
My lord, I am appearing for the judgment debtor, my lord.
And Mr. Bhatra for
Lord, I am
bank.
appearing for the net fee.
The
Okay,
bank.
okay, has it been settled?
Yes, yes.
Payment
has
been made.
This can be closed, my lord.
Close this. What was your cause of action?
My cause of action, my lord, that I claim to be a prior purchaser of the mortgage, some of the mortgage properties on which the original respondent number 6 had taken loan from the bank and defaulted, my lord. So the learned recovery officer, the DRT, my lord, during the recovery proceeding, issued, my lord, warrants of arrest and striking out my name from the mutation, my lord, record. Those orders were ex posi without jurisdiction. Those were challenged here. There's an interim order in place. Now that the account has been settled by the private respondent,
The account, my lord, the recovery proceedings will itself close.
itself be closed. My lord, Lordship may record that perhaps and my lord, close this petition.
Okay.
However, my lord, I'll just point out one thing, my lord. The orders which they have challenged ought to have been challenged for the presiding officer, my lord. So if the.
Because when the
report
tree is-
It is by the recovery of
Yeah, it's before.
certificate officer.
Yes, my lord.
Okay, doesn't matter.
Now there is nothing to challenge. No tree, matlab, what to talk of the branches.
Heard Sri A. Ganguly, learned counsel for the petitioner. You also heard Sri state is there a party. Also heard Miss M. Burman, learned state counsel, Sri R. K. Bhatra, learned counsel for the respondent number 2. And Sri T. H. Hazarika, learned counsel for the respondent number 6, 6.1 and 6.2. Where? Considering the facts and circumstances, the development which has taken place, which had taken place, and as agreed to by the learned counsel for the parties, this writ petition is taken up for disposal at the admission stage. Full stop. Para. Briefly stated, the petitioners have put to challenge orders dated 8/9/2023. Please have your seat. 8/9/2023 and 10/10/2023 passed by the recovery officer, DRT Guwahati. Full stop. By the aforesaid orders, the mutation in the names of the petitioners with regard to the lands in question under Bipuria circle in the district of Lakhimpur have been directed to be cancelled. The jurisdiction of the recovery officer, amongst others, is one of the grounds of challenge. Full stop. Sri Ganguly, the learned counsel for the petitioners, has however submitted that he has been informed that the matter has been settled between the respondent number 2, which is the financial institution, and the private respondent number 6, 6.1 and 6.2. Full stop. Sri R. K. Bhatra, the learned counsel for the respondent number 2, has submitted that the account has been settled as per an OTS on payment of rupees 110 lakh by the certificate debtor. Full stop. He has accordingly informed that there would be no requirement that the grievances of the petitioners would no longer be required to be raised. Para. Sri T. H. Hazarika, the learned counsel for the respondent numbers 6.6.1 and 6.2, has endorsed the aforesaid submission of Sri Bhatra and has confirmed that the matter between his clients and the respondent number 2 has been settled. In view of the aforesaid development, this court is of the opinion that the grievances for which this writ petition was instituted would stand redressed, and there will be no requirement to continue any further with this writ petition. Accordingly, the writ petition is closed. Copy of the order dated 18/8/2025 placed on record, placed before this court 2018/20 of the learned recovery officer number 1, DRT Guwahati, placed on record Placed before this court by Sri Bhatra, the learned counsel is made part of the records.
Well, there was an interim order passed, that means.
The interim order passed earlier is accordingly made absolute.
Deeply obliged.
Published.
Yes, please.
My lord, in the year 1983, my lord, 1 acre land was allotted in favor of my father, my lord. That is my lord, page 21, my lord, kindly see.
Item 10, the full. Forest assembly.
No, forest, no, the government, what's the forest?
We can go for disposal of this matter.
My lord.
Yes, what is it?
My lord, page 21, my lord.
Yes.
You see, by this, my lord, certificate, my lord, 1 acre land was allotted in the year 1983, my lord, in my father's name, my lord.
How much land?
My lord, 1 acre.
1 bigha. Allotted by whom?
My lord, Deputy Commissioner, Gwalpara.
Allotted or settled?
My lord,
Allotted.
allotted.
Yes.
Thereafter, my lord, after the death of my father, my lord, I am being the son, my lord, I have been possessing that settlement, my lord, by constructing, my lord, Pakka house, my lord.
Yes.
Thereafter, my lord, I have applied for getting allotment in 9M, my lord, that is page 33, my lord.
Yes.
Thereafter, my lord, without my lord notice, my lord, I have been evicted, my lord, by demolishing my entire household property, my lord, without notice, my lord.
When was it?
My lord,
When was it?
my lord, it was demolished on 17/7/2023.
Yes.
Thereafter, my lord, I have filed a representation before the District Commissioner Gwalpara, my lord. That is page page 39, my lord. But nothing has been done till that, my lord. And now, my lord, the District Commissioner Gwalpara filed an affidavit, my lord, in opposition, wherein he stated that the land possessing by me is my lord forest land, my lord. Which is totally, my lord, false, my lord. My lord. In
No,
there,
you have to tell us that the land from which you have been evicted,
my lord.
was it the same land which was given?
Yes, yes, my lord, yes.
That is the same land.
Same land, my lord.
Okay. Yes, forest is a party here.
My lord.
Yes, forest department. Mr. Das, what do you say?
My lord, with regard to the notice, my lord, it is very much clear. Our affidavit, it says notice has been issued, my lord. Regarding, my lord, the allotted land, allotted land, my lord, para 4, my lord, of my affidavit, my lord.
Yes.
It clearly stated, my lord, and Lakhipur is recorded as a government land, and during joint verification, along with the forest department, the land in question is found to be under reserve forest, as reported by the DFOT Gwalpara White number encroachment and eviction 418586 dated 5/11/24 as direction by the Honorable High Court, Guwahati. A comprehensive survey of the Nalbari Reserve Forest was conducted by the Range Officer, Lakhipur Range. During the field survey of the said, it was found that petitioner is one of the encroacher in the said reserve, as listed in the encroachment survey report of the Nalbari Reserve Forest, and compliance with the Honorable Guwahati High Court order and judgment in PIL so motto 1/22, my lord.
Yes, forest department. Names reflected in the cause list or not?
Yes, my lord. Reflected, my lord.
Last time also forest was not there. Why?
My
Why
lord.
this negligence?
Reflected, my lord. My lord,
He used to appear for the forest department.
Who?
Dixit Gogoi, my lord.
No, there are panel of lawyers.
I don't know, but perhaps, I don't know,
There are Gogoi is there, D. Gogoi, KP Pathak,
my lord.
I. Borthapur.
Can it be on my lord Thursday? I will inform.
You try to inform them, we can have it, these are old matters, or is not 24 does the, nonetheless, we had made an observation that if pleadings are complete, we'll have for admission hearing. You can have it after some time. It's not very complicated.
Not complicated.
Would like
Only
to get it
dispute
off-
of facts, my lord.
No, we'll like to see how you have stated that it is forest land.
Ever forest.
Mr. Hussain, after a while,
My lord.
we'll have this. Which one should we take up first?
Lordship, in this series, my lord,
Which one will take up which matter?
I think 6 and 11 after a while here, after few minutes, some other method will.
no, my lord,
We'll start with some other matter.
yes.
Which one?
For item number 5, my senior Mr. T, there is some.
Otherwise, Lordship can start with, my lord, item number 12, my lord. Item number 12, my lord, there we have filed a consolidated additional affidavit.
1439, is it 1439?
My lord, it is 2130.
2130.
And my lord, amongst these matters, my lord, Lordship may kindly mark, my lord, item number 5, 6, and 7. In these matters, my lord, the petitioners are already evicted. And no speaking order has been passed because, my lord, in pursuance to the earlier round of litigation where the court has given them a leeway, my lord, to file representation within the stipulated time, they have defaulted, my lord, they have not filed. So Lordship will kindly
Item
mark,
number 5, 6 and 7.
my lord, 5, 6, 7, then my lord, item number 8, 9, 10, then 16 and 17. These are the matters.
Already evicted.
Already evicted. And there, my lord, here no representation and no speaking order has been passed.
Five, 6, 7, 8, 9, 10, 16 and 17.
My lord, these are the matters where, my lord, they are already evicted. And so far as, my lord, this item, my lord, 11, 12, 13, my lord, 14, 15, this may be heard, my lord. And my lord, item number 12 will assume significance in the entire, my lord, batch of writ petitions because here we have filed the consolidated additional affidavit, my lord, which we are relying for the entire series. And we have
Yeah.
newly circulated copies to all.
That's, the copy has been served to other councils.
Yes, my lord, yes, each and every one, my lord.
Okay.
And they have also, in some of the matters, they have filed reply.
Rejoinder,
also,
okay.
my lord. The pleadings are absolutely complete, my lord. Yes, sir.
Okay.
So far relating to item number 6, Lordship, I was, my lord, tried to partially evicted. I was not evicted in this case, my lord. Your Lordship kindly come to the, my lord,
Which matter will take up first?
item number 6.
The WPC?
Yes, my lord.
WPC what?
WPC 1376/2025, my lord. Lordship, I want to show something, my lord, before making the submission, my lord. Lordship, there is an order here, as your lordship, Honorable Justice, my lord, D. Borua has passed, my lord, formulated 6 line, my lord. And your lordship kindly come to the, my lord, that notice, my lord, eviction notice, my lord. Page 96. 5/3/2020. What he is submitting, I deny all these things, my lord. 5/3/2000,
Page?
page 96, my lord. I GUCU 27/24/31 to issue from the office hereby again inform you that as per order office 3715 Oberoi High Court, filed order dated 27/1/2000 issued by the This is to notify the you to vacate within 15 days covered by Ulubari belong to TB hospital, which is unlawfully encroached by it. It is already 15 days past. It is seen that you have not vacated the land. The said encroachment has been decided to vacate on 6 and 7 March. Therefore, we inform that encroachment immediately after receipt of this notice. Where is that we are not submitting anything, man? And who has issued that notice? That circle officer, man. Lordship, kindly come to the SD eligible circle officer. I am reading the Assamese part also, man. Page 97. A কাৰ্যালয়ৰ, have you also got it, man? A কাৰ্যালয়ৰ যোৱা 30/1/2000 তাৰিখৰ গৈছে উচ্চতম ন্যায়ালয়ৰ 27/2014 জাননী লেখেৰিত পুনৰ আপোনাক জনোৱা হ'ল যে মহামান্য উচ্চ ন্যায়ালয়ৰ 37 গোচৰ নিৰ্দেশ মৰ্মে জিলা উপায়ুক্ত তাৰিখৰ পৰা উত্তমে টিভি হস্পিটেল আপুনি বেদখল কৰি থকা এইটোকে জাননীৰ পৰা 15 দিনৰ ভিতৰত জাননী কৰা হৈছিল। বেদখল জাননী কৰাৰ পিছত 15 দিনৰ পিছত বেদখল মুক্ত কৰা নাযায়। উক্ত বেদখল মুক্ত কৰাৰ আগতে 6-7 মাৰ্চ তাৰিখে ধাৰ্য কৰা হৈছে। এই জাননী মাত্ৰ পোৱাৰ লগতে বেদখল জমি পুনৰ মুক্ত কৰাৰ কাৰণে অনুৰোধ জনোৱা হ'ল। এই আইননি ধাৰ্য কৰাৰ মতে উচ্ছেদ কাৰ্য সম্পন্ন কৰা চিলমোহৰ বাইদেউ চক্ৰ বিষয়া ৰাজহ চক্ৰ। In this matter, my lord, photocopy to. Your lordship, kindly come to the my lord. This order has already been passed. Circle officer has, my lord, no power to issue notice, my lord, in respect of that, my lord. Lordship, kindly come to the, my lord, para 7. It appears this court fight efforts and ordered the 7/11 to have directed the Commissioner Kamrup to give an opportunity of hearing to the petitioner. Impugn notices, however, we are not issued by the Deputy Commissioner but the Circle Officer Guwahati. This court is therefore opinion without making any comment intermarried rival party ground that notice has been issued by the authority was not mentioned in the direction directed 7/11 said notice were interfered with. It is made clear that only on the ground competence of the Circle Officer Guwahati Revenue Center, and there would be no bar for the authority. Authority named the order 7/11 to take action in accordance with law. My humble submission, he has no authority, my lord. He has no competence to pass this order, my lord. Secondly, in the notice, they were no stated. You are fault to give any, my lord, reply. That is my humble submission before your lordship, my lord. If because jurisdiction is not competent, this order shall go, my lord.
No, the notices have already been interfered with. By giving another opportunity to the competent authority to issue notices. This petition was allowed.
That's fine.
Thereafter, what happened?
Thereafter, my lord, I don't know. Thereafter, I think no notice was issued.
If I may place.
My humble submission before in respect of my lord, diag number 96, my lord. Your lord, 96 is that. That 96. That was interfered with, my lord, and that order has been set aside, my lord. Thereafter, my lord, I do not know whether any notice has been issued or not, my lord. That is my humble submission. They issued, my lord, notice, my lord.
No, this particular case which you are arguing, 1376 of 2025,
Yes, my lord.
pertains to DAG number 97.
Yes, my lord.
Correct?
Yes,
And the earlier writ petition which you have relied upon, 4625 of 2025,
yes, my lord.
pertains to a different DAG,
Different DAG.
wherein this court has interfered
Interfere.
by saying that the earlier order of this court, which was passed in 3715 of 2025,
Yes, my lord.
3715 of 2020,
Yes, my lord.
only the deputy commissioner, district commissioner
Yes,
was
my lord.
given the.
Yes, my lord.
Now,
And on that
now
point-
in your present case, again, there is a notice by the circle officer.
Circle, that is submission.
So you are making a submission that on the same lines,
Yes, sir.
this notice should also go.
Go, my lord. That is my humble
Yes,
submission.
yes.
My lord, the reply will be, my lord. My lord, in that decision, which my lord, my learned senior colleague is referring to, there the petitioner is in occupation. He is sought to be evicted. Here is a case where we have, my lord, categorically stated in our affidavit. Now, my lord, this statement, my lord, at page 97, which lordship is now saying, my lord, the pleadings in the writ petition my lord, is to be found, my lord, at paragraph 22. Lordship may kindly see, my lord. Paragraph 22, Lordship may kindly come to page 15 of the writ petition, my lord. Page 15.
Yes.
Page 15, my lord, paragraph 22. The petitioner begs to state that the circle officer, Guwahati Revenue Circle, as well as the Deputy Commissioner, Kamrup Metro, in their reports clarifications have categorically stated that the land bearing DAG number 12 old 97 new is beyond the boundary of TB Hospital and the said land is not allotted to TB Hospital. Further, in respect of one Modern Biswas and another Bankim Chandra Biswas were allotted patta in DAG number 97 new. And so far, one Arun Singh and another Sail Devi, the government in the Department of Revenue and Disaster Management has accorded approval for settlement of land by giving patta in DAG number 97 by realizing premium at the rate of 30% of the zonal value. Even after the reports of the respondent number 2 and 4, the petitioner is surprised to state that the respondent number 4 on 5/3/25 woke up from slumber and has issued impugn notice dated 5/3/2025.
Now, this is the statement of fact. Then what happened?
Yes, my lord, this is the statement, my lord, to which, my lord, we have replied. If lordship may be pleased to take up our affidavit in opposition, my lord, it starts from running page 144. It has been filed by the circle officer. And relevant portion, lordship will find at page 148, paragraph 9. Where, my lord, the statements made in paragraph 7 has been reiterated. Now, if we come to paragraph 7, my lord, lordship.
144.
Yes, my lord.
Page 44, 144 is your affidavit.
Yes, my lord. Running page 144. My lord,
Yes, is your affidavit starts.
yes, my lord. Affidavit in opposition filed by Raja Boissa, the circle officer, on behalf of respondent number 2, 3, and 4.
Correct, ma'am?
Yes, which paragraph? would you like to-
Yes, lordship may kindly come to, my lord, paragraph 7. Because, my lord, with regard to paragraph 22, we
No,
have,
Mr. Bopuje, we are not on that.
no, my lord,
What Mr. Chaudhary is trying to say is all these actions were preceded by the order passed in 3715 of 2020, wherein the court had made an observation that the deputy commissioner can proceed. Now, the action was not taken by the deputy commissioner, but by the circle officer.
No,
And in one of the cases, that was the ground of interference, which was, interference with a condition that if it is proceeded by the deputy commissioner, the court.
absolutely.
Now, he says, so far as this case is concerned, it is again the circle officer who had proceeded.
Therefore, my lord, he will have to first of all establish before this honorable court that in pursuance of the earlier round of litigation, where strict directions were issued, that they will file representations. My lord, unless and until they file representation, we cannot take a call, my lord. So that is the condition precedent. A duty is also cast on them. He is now showing fault on us. But at the very first instance, it is for him to lay a claim that he has a bona fide right of claim by filing a
He
representation.
will respond to which, was there any direction from this court to straight away file representation?
No, my lord, those notices in the earlier round of litigation, those were to be treated as the representations. This was the direction from the honorable court.
Okay.
So therefore, lordship will kindly see, my lord, kindly see the honorable court's direction, my lord. My lord, more particularly at page 94 of the writ petition, for a moment, my lord.
94.
Yes, my lord, 94. That is a part of the order. So this is the genesis. This order is the genesis. Page 94 of the writ petition.
Yes.
My lord, paragraph 50. Accordingly, this court therefore disposes of the instant batch of these writ petitions with the following observations and directions. The impugn notices issued under Rule 18 so issued to the petitioners to vacate shall be construed as notices issued by the Circle Officer, Guwahati Revenue Circle, to show cause why the petitioner should not be evicted by taking recourse to Rule 18 of the settlement rules. So the court has, my lord, called out a deeming provision in this, my lord, direction. Those notices were not issued by the district commissioner, rather by the circle officers. Nonetheless, my lord, this honorable court came to a finding, my lord, that for a fair adjudication of the matter, those notices may be treated as notice of show cause. To which, my lord, they held the petitioners in the present batch of writ petitions are given the liberty to submit their individual replies and substantiating the same with documents and such evidence as deemed proper, thereby showing cause that the petitioners have a bona fide claim of right involved in respect to the land under their occupation, and as such, recourse to Rule 18 of settlement rules is not permissible. So they were
So
given
let us first understand the
the liberty.
directions. First is that the notices which were issued under section 18 should be construed to be notices issued by the circle officer. Okay, Guwahati, to show cause as to why recourse should not be taken. Number one, petitioners in the present batch of writ petitions are given liberty to file individual replies.
Yes.
Number three, liberty is given to be exercised within 30 days.
Yes, this is of paramount importance. Because the
Then
timeline
number
is
four,
fixed.
deputy commissioner will give a hearing.
Absolutely.
Now they did not file any reply.
Therefore, they will have to show.
My lord, my humble
No,
submission.
we'll come back to it.
They will have to show. And therefore, my lord, the deputy commissioner is directed to give an opportunity and thereon pass appropriate speaking orders. So this is, my lord, the direction number, my lord, 4, Roman 4 in paragraph 20. Now, lordship will kindly see, my lord, what is our reply to that paragraph, my lord, more particularly to the notice which lordship has just now seen, my lord. Our reply is that, my lord, that paragraph 7. Paragraph 7, my lord, page 146, paragraph 7 of my affidavit. That with regard to the statements made in the deponent begs to state that eviction notices were served to the petitioners from office of the circle officer, Guwahati Revenue Circle, by letter number so dated 5/3/25, and they were evicted on 7/3/25. Lordship will kindly mark these dates, my lord. They were already evicted. They were already evicted on 7/3/2025 from the land in question, as the petitioners were illegally occupying the land reserved for TB. As per record available in the circle office, the land covered by Dak number 97 of so and so is a government land, and there is a total land measuring 24 bigha 4 kotha 12 lesa under the said government Dak. The land is recorded in the name of TB Hospital in the remarks column of Chitha. The deponent further begs to state that the land of TB Hospital will be used for construction of Pragjyotispur Medical College. The meeting of the SDLSC held on 19/2/2022 took a decision of allotment of land for the second medical college in Guwahati, which includes the land allotted to TB Hospital along with other land. Subsequently, by notification dated 11/3/22 issued by the.
Mr. Borpujari.
Yes.
Just a minute. The order which Mr. Chaudhary has relied upon in 4625,
My lord.
4625, that order has been relied upon. right?
Yes.
Now, this order is in respect of an order dated 7/11/2024.
7/11/2024. Yeah.
See, we should not mix up with two things.
Yes, ma'am.
The initial notice issued by the circle officer, that was in fact ratified by this court.
Yes.
The only thing was that the deputy commissioner, if the show cause is filed, deputy commissioner will give a hearing and pass an order. In this order which has been placed reliance upon, he has said that 7/11/2024 is not passed by the deputy commissioner but by the circle officer. Now 7/11, whether this is the initial notice or notice to vacate.
Notice to vacate.
Then notice to vacate, then only you have initial notice by the circle officer, we have not found fault.
Absolutely. So the 7/11/24 order is the same order. which
Mr.
was
Chaudhary,
issued.
this order is on a different context, where the final order of eviction has not been passed by the
Yes.
deputy commissioner but by the circle officer.
Yes, my lord.
So
Yes.
far as the initial notice to show cause
We
is
are
there,
not receiving the notice, man. That is the problem. He is mentioned.
but the observation at subpara 1 of page para 50, that was construed,
Man, this is the final notice that is the issued by the circle officer.
yes.
Yes, my lord. And earlier notice what he has mentioned, my lord, In the order, it was not reflected that earlier notice has been, he has failed to comply the order. He is submitting this, no notice has been served to the petitioner, my lord, my humble submission before your lordship. And the writ petition.
No,
this is-
after the observation of this court,
Yes, my lord.
that the notices under section 80 so issued to the vacate shall be constituted to be notices by the circle
We are
officer.
not the party on that petition. That is the problem.
We would never.
We are never party on that writ petition, my lord. They have come, 3-day notice has been given, circle officer. It's partially evicted, but we are not, we are giving reply, my lord, of in respect of eviction, my lord. And I have the photograph also, my lord. Your lordship, kindly come to page 188, my lord, affidavit in reply filed by me, my lord.
You are not petitioners in
Yes, my lord.
this case,
Yes, my lord. I am not.
3715.
Yes, my lord. I am not the petitioner. Page 188, my lord.
মই সেইটো সোধা নাই, মই সুধি আছো নাছিলে।
3715 you are not petitioners.
No, my lord. Page 188, my lord. Of my reply. That as regard, have your lordship got?
Yes, please read.
That as regard the statement made in para 7, which is read, is incorrect, baseless, misconstrued, as such denied by the deponent. The deponent further said notice was served on 5/3/2021, but never evicted from the, although respondent authority were tried to evict the petitioner by damaging some portion of their land, damaged house, but the petitioner was not dispossessed from the aforesaid land. The deponent denied the statement, the aforesaid plot is land in the name of TV Hospital from Sitha. Because, my lord, your lordship has already verified that.
No, this notice at 3/5/2025 96, page 96 is issued to whom?
I don't know, my lord. This is
No, 96, page 96.
My lord, my humble submission.
No,
Yes.
kindly 96.
Page 96, my lord. And this was issued to me, my lord.
Okay, now what is your grievance now?
My grievance is that, my lord, this is the first notice I have received, my lord. I have
Yes,
stated.
thereafter,
Thereafter, after 3 days, they come, tried to evict the petitioner, could not evict, my lord. I have got the photograph and I have denied all these things, my lord. Could not dispose the petitioner from the land.
no, after 5/3 issuance of this notice, you are immediately evicted.
Immediately after 3 days. 2-3 days.
So therefore, my lord, disputed.
At least, my lord,
We,
16 days, 15 days time should be given, my lord.
Now, how can you make this, Mr. Borpujari?
no, my lord, my submission is different. my lord.
They were not petitioners in 3715, that is what Mr. Chaudhary has. You can dispute, but if to dispute, you have to dispute on the record, on the basis of the records.
No, therefore.
They were not parties, number one. So, but still then it doesn't matter. You can still proceed in accordance with law. You serve a notice on 5/3/2025 and on within 3 days you evict them.
Now, my
And
lord.
this is the photograph I have
Phot-
taken.
Photograph is
So,
okay.
so therefore, my lord, what is the position evident on the face of the materials now available, my lord? Lordship will kindly say, my lord. I take, my lord, that this notice is not in the nature of a show cause. My lord, it doesn't fulfill, my lord, the dictum pronounced in Salakuddin, as well as, my lord, the earlier directions which lordship has just now seen, my lord, in the common order at page 94, those 5 directions. My lord, evidently it doesn't confirm, my lord. I take it, my lord. But nonetheless, my lord, we say, my lord, this notice was issued on 5/3/25 and they were evicted on oath. This affidavit has been filed, and we say, my lord, that they were evicted on 7/3/2025 from the land in question. Now a dispute has arisen. They now try to say that they are not completely evicted, they are partially evicted. So the issue here will be, my lord, whether the possession can be restored in respect of the petitioner. Possession ante can be restored on the basis of the dispute raised on the basis of the materials on record.
I never asked for possessor. First, there is a status quo as on today shall be maintained. The word I have used, my lord, because I was not.
Just one by one.
Sorry.
Link to খেলি হৈ যাব, thought process টো বেয়া হৈ যাব, please. Now, my lord will kindly say, my lord, we say that they have been evicted. Notice on 5/3, we say they have been evicted on 7/3. Now they raise a dispute on facts. Even if, my lord, status quo is ordered, my lord, is it not a case, my lord, for them to seek declaration, my lord, before the appropriate civil court because of the dispute? because of the.
When was the order of status quo passed?
There is no interim order passed, my lord. We are there, my lord. We are not
Because-
evicted till today, my lord.
Therefore,
My humble submission.
Okay, welcome.
So therefore, my lord, therefore, if interim order was not granted in favor of the writ petitioner in this writ petition, evidently because of the fact, my lord, taking into consideration of our submission at the very first day, my lord, that they were already evicted and the petitioners have not even faced for any interim order. So that aspect of the matter, my lord, still hold the field, number one. Number two, my lord, if they now say, my lord, that they are partially evicted, meaning thereby that they are still in occupation of the plot of land. We say that they are not in occupation of the plot of land. Now, who is going to decide, my lord? Because evidence has to be laid. On the basis of the materials on record, my lord, there is a clear dispute on fact. I am only on that, my lord. On the factum of dispute, my lord, can this honorable court, my lord, arrive at a finding, my lord, without there being any convincing evidence, my lord? That, my lord, that they were not evicted or they were partially evicted. I presume, my lord, that this notice doesn't confirm with the dictum pronounced in Salahuddin as well as, my lord, the dictum pronounced by this honorable court in the earlier round, my lord.
Mr. Chaudhary, just
My
take a
lord.
second. Come to the relief which you have prayed for at page
Yes, ma'am.
19. Page 19, please come.
My, your lordship, kindly come to the prayer portion now.
Yes, prayer at page 19.
Fine. My, first, I may clarify this position,
No,
my.
no, please read.
Yes, my lord.
We have not asked for any clarification.
My lord, under the above circumstances, your lordship would be pleased to admit the call for the record, page 19, my lord. Should not setting aside and quashing the notice dated 3/5/2025 as to why a repeat mandama should not be issued for the
Okay,
direct and
so the
direct-
main challenge is
Yes.
against the notice.
Yes, my lord.
You have prayed for a writ of certiorari
Yes,
to
ma'am.
quash that notice.
Yes, my lord.
Now that notice has been acted upon, you may say partially,
Yes, my lord.
and he may say in total. Now, that notice part has gone. We are not saying that you would be left remediless.
Yes, my lord.
What relief can you,
Yes, my lord. My
what
humble
relief in
submission
this
before-
writ petition?
My humble submission before your lordship is that, my lord. Notice was not done, my lord. They come to the my place, my lord, partially damage the house. They could not evict. I have some photograph also, my lord.
No, Mr. Chaudhary,
Yes,
we have understood your
Yes,
case.
my lord.
Now,
My
what?
humble submission
No,
before your
can,
lordship.
kindly listen to the court. What kind of relief are you expecting from
Because,
this
my
court?
lord, they have issued the notice under Assam Land and Revenue.
Now, what kind of relief are you expecting?
My expecting my humble submission before your lordship is there. They should be called for hearing, my lord. And my lord, after calling the hearing, I shall submit all these things.
That can be done for
Yes,
the,
my lord.
if any part is remaining.
Yes, my lord. And my.
If any part is remaining, that can be done.
My lord, that is the my submission.
But the relief of setting aside the notice perhaps has become infructuous.
My-
If you are aggrieved by an illegality by which you have been unauthorizedly removed, you can seek compensation in the appropriate court.
No, my lord, my humble submission is something
Absolutely.
different, my lord.
But so far as your other prayer is concerned,
Yes, my lord.
if you are still in possession, we can direct them to issue notice.
My lord, my.
And notice what? You are in this court, we can assume that notice is served.
Yes, my lord.
That is true, my lord. My lord.
Para 6.
That this honorable court lordship will definitely direct in pursuance of the
Right.
submissions made by him. But I am on the materials on record. We clearly say, my lord, that they have been evicted. They say that no, we are partially evicted. We are still in possession. So who is going to determine, my lord?
Where is your statement that you have
Yes,
been?
yes, kindly see,
I
my lord.
also stated, my lord, in my
No,
opinion.
Therefore,
Where?
my lord, paragraph 7 of my affidavit, my lord,
Page
page 146, my lord. with all respect.
146.
Yes, my lord. Kindly see, my lord.
146.
My lord, kindly see.
It will be approved.
Paragraph 7.
Paragraph 7.
Please read.
Yes, with regard to the statements made in paragraph number 20 of the petition, Nippon makes a state that eviction notices were served to the petitioners from the office of the circle officer, Guwahati Revenue Circle, Vice so dated 5/3/2025. And they were evicted on 7/3/2025 from the land in questions as the petitioners were illegally occupying over land reserved for TB hospital. My lord, we have clearly stated, my lord, in no ambiguous terms, my lord.
Lordship, kindly come to para 7 of my petition. Because the statement of what made by the parcel operator.
Just a minute, please. Mr. Chaudhary, where is your reply to 7?
Yes, my lord, page 188, para 6 of my reply.
Yes, we have read that.
Yes, my lord. Then as regard the statement made in para 7, it is incorrect, baseless, misconceived, misassessed, denied by the deponent.
Hmm.
Deponent fathers said their notices served on 5/2/2000, but they were not evicted from their plot of land. Although the respondent authority tried to.
Where?
Para 6, my lord,
Para 6 at page
188,
by Full Money Talukdar.
full money talukdar, my lord.
Para 6.
Yes, my lord. Of affidavit in reply filed on 19.
Deponent further states that they are already, as already stated by above, land has been settled with Madan Mohan Biswas. That one.
No, my lord. Para 6, that is my lord. Point 6, para 6, page 188. It was filed on 19/8/2025.
By who?
The deponent is, my lord, Pradeep Shah.
Pradeep Shah.
Pradeep
And
Shah.
Who is Full Money Talukdar?
Full money
Full money
talukdar, petition
talukdar.
number 1.
P1.
Yes, my lord.
P1 is Full Money Talukdar.
Yes, my lord.
And
And
then
Pradeep
lordship
Shah
will-
is petitioner number 5.
Okay.
Pradeep Shah is P5, my lord,
Yes, my lord.
P5.
Yes, my lord.
Separate reply, rejoinder affidavit.
Yes, my lord.
Reason, the only one reason the affidavit in reply against our affidavit.
There are 2 rejoinders.
Yes, my lord.
No, this is the additional affidavit, my lord. One I find here with my.
No, there are 2 rejoinder affidavit. One by Full Money Talukdar.
My lord, there is a thing, my lord. One is a comprehensive affidavit has been filed. That is full money talukdar is the reply of that affidavit. And this is the affidavit filed by them. This is the reply. What I said.
Petitioners.
On
Okay,
full.
let us see paragraph 7.
Paragraph 7, that as regard the statement made in paragraph 7 of this is incorrect, baseless, misconceived, misconstrued, and as such denied by the deponent. The deponent further state that notice was served on 5/3/2025, but they were not evicted from their plot of land. Although the respondent authority were tried to evict the petitioner by damaging some portion of the land, but petitioner was not disposed of the aforesaid land. Deponent denied the statement aforesaid land in the name of TB Hospital in Sita. And my lord, the deponent further said land TBOC is the SLDC took a decision, Second Medical College Hospital, issued by the family of the Second Medical College Guwahati. The deponent as per Annexure B, minutes of the meeting dated, dag number so and so, Assam does not mention the land of TB Hospital. And my lord, my humble submission before your lordship is that they have affidavit filed in other cases. 97 dag is not in the for the TB Hospital, my lord. They are minors, my lord. And so far relating to my lord,
Mr. Chaudhary, the problem with in this case would be in writ jurisdiction if there are disputed questions of fact.
my
How do we?
my humble submission before your lordship is that, my lord.
Yes.
First is that, my lord, that 5/3/2025, that notice has been issued without jurisdiction, as already appointed by this honorable court, my lord. Moment it is without jurisdiction, my fundamental right has been violated, my lord. And that is why I am submitting a notice has been given. I should give an opportunity to hear the matter. And what he has said, my lord, blatant lie, I can show. This is the photograph. If your lordship made an advocate commission, go to the place. I was not evicted till today, my lord. My lord, sometime, my lord, all the he want to say, my lord, all the statement of the circular gospel to.
Mr. Chaudhary,
Yes, my lord.
we are not on the interest and merits.
Yes, my lord. I'm not-
Violation of 21, 14, those are there. But on the matter of fact,
Yes, my lord.
he says, the respondents say in their affidavit that on 7/3/2025, you are evicted. In your rejoinder, you say you are not evicted.
Yes,
Now, how do you go ahead?
I am not on that. Let them status quo maintain, my lord. Because I am on notice, my lord. In that notice, they have not given effect, my lord. Because I have categorically made statement, I get the evidence also. Hello, check, I'll go to this photograph, my
No,
lord.
photographs in a writ court, how much it will have?
No, but tomorrow, if this type of case, they say they already been evicted. This type of stand they will take in, my lord. And I want to say, my lord, something different, my lord. There are other law also, my lord. They, as per my lord, settlement rules. TA. Have a lordship got it?
No, Mr. Chaudhary, we may be wholly with you on the point of law,
Yes, my lord.
but on the factual dispute, he says something else, you are saying something else, both are saying something on affidavit. We have checked the verification part also.
Yes, my lord.
It's on affidavit. How do you go ahead? Read court.
Lordship may issue a commission, my lord.
Why read court? Why?
Yes, my lord. My humble submission before your lordship is that, my lord, without giving any opportunity of hearing, and as per rule, my lord, that law, my lord. Assam
Mr. Chaudhary,
settlement.
you are not understanding the question. We have said that we may be 100% with you in your principle, the
Yes, ma'am.
exposition of the principles of law.
Yes, my
We
lord.
are only on the factual part.
Yes, my lord.
You said you are not being evicted, they say you are being evicted. Whether your eviction is in accordance with law or not, we have not said anything till now. We may still say
Yes, my
that
lord.
the notice is by an incompetent authority, notice is violative of 21.
Yes, my
All
lord.
those we may accept.
Yes, my lord.
But will it restore possession if you are already evicted? And they said you have already been evicted. So how do you come to a determination on factual dispute?
Lordship, kindly give me some time. I shall produce the judgment in this type of my lord. Because, my lord, I want to say this circle officer has stayed blatantly lie, my lord. Even necessary, I shall file affidavit along with all proof, and I shall see the judgment, my lord. Only some time, my lord. I shall get this. And when the fundamental right has been violated,
Sir,
my lord,
Chaudhary, judgment you may rely upon, but judgment will not help. If there are disputed questions of fact, it will be difficult for us to embark.
in respect of disputed question of fact, some judgment is there, my lord.
Hmm.
I have, my lord. In other cases, my lord.
In read court,
Yes, my lord. I have to go to the Digoli Pukuri, find out the judgment, my lord. There is a judgment. I have appeared in case just now.
you go to Diguli Pukuri for judgment.
Yes, my lord.
Have a swim over.
Yes, my lord. I will find out.
Judgments are available at Diguli Pukuri.
Yes, well, I find out a
We
bunch
never
of my
knew
lord.
that.
A judgment of
We'll also go there.
disputed question of facts, my lord. In respect of judgment. I shall try my lord. Last chance, my lord.
It's a clear-cut case of oath versus oath. My lord, in every jurisdiction, when the situation is such, my lord, that there is a oath versus oath, my lord, Supreme Court is clear, my lord. Apex Court is clear, my lord.
No, I am coming, my lord. I am giving all the answer of his question.
It's a case
When
of
can
oath
you
versus
come?
oath.
Lordship, kindly give
How
1
long
week-
will your
1 week time,
swim
my lord.
be?
1 week time.
You will swim for 1 week.
1 week. For this case, man, other case, no.
You will not be able to sustain for 1 week in the Diguli Pukuri. Even 2 minutes we doubt.
এটা তো নিবেদন তো আছে, এটা সংস্থা আছে। এটা সম্পদ দিয়া নিবেদন তো আছে, ভোট আছে।
I will accommodate you, don't worry. When Tuesday next?
This must be the so. Tuesday, oh. September.
Tuesday?
My lord,
Can it be, my lord?
any date, my lord.
My lord, Thursday.
11th, Thursday problem. Thursday will rise early.
Then my lord. It will be doable. Wednesday,
11, not Thursday. Jaldi se. Huh?
Wednesday.
Tuesday we can try. 10th. Tuesday have a difficulty.
That's fine. I only saw the dispute.
No, Tuesday, are you around in Tuesday? Okay. No, but other matters we are going ahead.
Yes, no,
Now.
I want to submit one thing, my lord. First, my lord, this notice is not the other settlement rules. The stand taken by the government, my lord.
Now this submissions were with respect to item number 6.
6.
6 we'll have it on Wednesday. Other matters?
7, 8, 9, 10 also, Lordship. 7, 8, 9, 10 also.
Why?
They stated that we have been evicted, but we have not been evicted. Only banner was hanged that from today this then belongs to city also. That
You are in position.
yes, Lordship.
They are repeating.
7, 8, 9, 10. Same Lordship. It may not be.
Now, what about 5?
I were my Lord Philip.
5 evicted or not?
5 evicted, your lord.
Evicted.
5 evicted, and they were, my lord, party in the earlier round of proceeding.
Oh,
If they missed the bus, they didn't file representation. That's how. So
so what
therefore,
kind of relief are you expecting, Mr. Deori?
May I submit your lordship, in this case,
Even if you make it a case that it is fraught with illegality, then we can give you liberty to approach the civil court for damages.
No, it's not
But-
illegality, your lordship, but what my respect for submission is that we have to be at least given some scope, your lordship. Rehabilitation, no rehabilitation has been done. As per Olga Tellis and Chameli Singh, your lordship, we should have been at least given the rehabilitation part. That was not done. That is my respectful submission before this honorable court. We respect
Now,
the
rehabilitation for whom?
bona fide for the persons who have been there for.
What
last
is
30
your, what do you do?
We have been working here, your lordship, only because of, we cannot afford a piece of land in.
What do you do?
Lordship, I'm a small shopkeeper. With respect,
Where?
I-
How small is your shop?
Small shopkeeper. Right. One.
Rehabilitation is for persons who deserve it.
True, your lordship. But we have been here for the last 25 years, your lordship. At least.
That is okay, but over what khas land?
Yes, your lordship.
If it is reserved for a particular TB hospital, then how do you? What do you do? What is your bank balance?
That has not been stated, your lordship. I'm extremely sorry. I have to take instructions. from
You have properties where?
Only here, your lordship. Only that particular plot of land, your lordship. It's a very small plot of land.
Doesn't appear.
Yes, your lordship. Only 7.5.
What is your shop about?
7.5 letters, your lordship.
What is your shop about? Small shop?
please. Thank you.
That is not stated, your lordship.
How many members are there in your family? You're trying to make a case of 21, you have to state the basic facts. This is my only source of livelihood, this is the income which I derive. These are the number of families.
Yes, your lordship.
You have not stated anything about your family members, details. And what about the other cases, other than this 5, 6, 7, 8, 9, 10, 16 and 17?
16, 17, 18, 19, 20, 21, 22, 23, 24, 25, I'm appearing, your lordship.
Hmm.
All the cases are same, your lordship. In the other
Evicted.
cases,
Evicted.
not evicted. In only one case, Jawahar Purve, I'm evicted. On the other case, I'm not.
No, that is it. We're trying to distinguish which Mr. Borpudari has said. 5, 6, 7, 8, 9, 10, 16 and 17 already evicted.
Already evicted.
We can segregate those cases.
Okay, and in my lord, so far
And
as
the other matters,
other matters, my lord, speaking orders have been issued, which have been put to challenge.
we can decide those cases today.
Absolutely, absolutely. And in my lord, so far as this item number 5 is present, concerned, my lord, where my colleague Deori is appearing, my lord. Here we have taken a definite stand that they are evicted. They have not filed representation in terms of the earlier order.
No, they were parties there.
Parties.
Yes, yes, sir.
Now, what is the paramount importance is that, my lord, against our affidavit in opposition, there is no reply from their side. So this is how the matter stands. Item 5 is concerned, my lord.
And let us try to segregate these matters, 5, 6, 7, 8, 9, 10, 16 and 17.
My lord,
Let us try to have a look at the other matters.
my lord,
We can have this 5, 6 on Wednesday next.
absolutely, my lord.
Okay, Mr.
Absolutely.
Deori, Mr. Chaudhary? Wednesday next. In this
5, 6, 7.
bunch of matters, common, so far as WPC लिखिए हाँ मैं item बोलता हूँ. So far as WPC 5, 6, 7, 8, 9, 10, 16, 17 are concerned, comma, the petitioners in these cases. Bharpujari Koloniti, Naipana. So for the batch of concern, three, R. Bharpujari Learners, Standing Council Revenue has submitted that so far as WPC so 5, 6, 7, 8, 9, 10, 16, 17 are concerned, the petitioners have already been evicted. Full stop. Sri NNB Chaudhary, Learned Council appearing in WPC 1376 of 2025 has however contended that the petitioners are still in possession of the land in question. Full stop. Similar submission has been made by Sri R. Dhar, Learned Council in
7, 8, 9, 10.
7, 8, 9, 10. हाँ उसका भी WPC लिख दिया 7, 8, 9, 10. Para. On the aspect as to whether our writ court can traverse into issues involving disputed questions of fact, Sri Chaudhary, the Learned Council, has prayed for some time to obtain necessary instructions. Para. List on 10th. Yes. Now we take up the other matter.
Yes.
Which one?
Lordship may be pleased to take up item number 12. There we have filed a consolidated.
11.
The 11 is also there, but my lord, in item number 12, we have filed a
Okay,
consolidated.
12, who is the council?
R. Dhar. Rupak Dhar.
Mr. Dhar?
Rupak Dhar and A. Matliki. Monetary addition, technically, that's for very.
Item number 12 will take up,
Yes,
isn't
but
it?
yeah.
Well, item number 11 may be taken first. Ma'am.
12, there is a consolidated affidavit.
They have also replied, madam.
Oh,
In that affidavit in opposition.
your savior has come.
No, it is 11 to 2.
Huh? 12.
11 and 12, these are similar, my lord, but in 12, my lord, we have filed a consolidated affidavit. So, my lord,
12 is Tutumuni.
yes, my lord, 2130. Here, my lord, the entire factual background, my lord, has been called out, both by the writ petitioners as well as, my lord, by the state authorities.
You are challenging the order passed by the deputy commissioner.
Yes.
Yes, yes,
Yes.
Yes, please.
at page 94.
90.
Lordship is to examine whether this speaking order is whether it is a speaking order or not. Actually, it is a speaking order or not. Page 94. Speaking order dated 26/03/2025.
Page
Page 94.
94.
Lordship. Whether it is in conformity with the judgment at para 50.
At page 69. Judgment dated 7/11/2024.
Yes.
Yes. sir. My lord, that 7/11/2024 judgment, my lord, which lordship has seen in the earlier round of.
Yes.
There are 69, yes, my lord.
You are
Yes.
challenging page 94.
94.
Yes. 26/3/2025.
Yes, Lordship, 26/03/2025.
Yes.
Whereas the Honorable Guwahati High Court in its judgment on the writ petition case number so-and-so had directed the District Commissioner Kamrup Metro District to give an opportunity for hearing to the concerned petitioners. Whereas the district commissioner, Kamrup Metro District had authorized the co-district commissioner, New Guwahati co-district to conduct individual hearing to the petitioners by order dated number so and so dated 9/1/2025. Accordingly, the co-district commissioner, New Guwahati co-district submitted his report by number so and so dated 19/3/2025. Whereas the disputed government land has been reserved for TB hospital and the applicant is in unauthorized possession of the land and had submitted application for settlement. Whereas the inquiry by the co-district commissioner, New Guwahati co-district concluded that the settlement petition of the petitioner is not acceptable as per land policy 2019 and rules thereof. Therefore, in view of the above, the settlement petition of Siminal Hazarika, son of so and so is hereby rejected and disposed of. The circle officer, Guwahati Revenue Circle, is directed to take further necessary action in accordance with law. Thereafter, also that notice was issued on 11/4/2025. Whether that notice was issued under 18 of the Assam Land and Revenue Regulation.
Which
I think
notice, page?
Page 95 is the type copy and 96 is the vernacular. It's the same notice which my learned friend has read out earlier also.
No, this is not the same. Notice. This is third, I think, March of, this is April.
Contents is same.
Yes.
Actually, now Lordship, if your Lordship comes to the affidavit in reply, which was filed on 29th of June 2025.
Reply affidavit, by whom?
By the petitioner.
Yes. Yes.
Page 134 of my reply, which is annexure 7. One of the letters which was.
No, this affidavit is by Tutumoni Hazarika.
Yes, Lordship.
This is dated 24/6/2025.
Yes.
Page 122, page 122. Twenty-four? Yes.
Now I beg to take your Lordship to page 134. This is a letter.
134?
Yes, Lordship. This is a letter from the Commissioner and Secretary, or from the Deputy Commissioner to the Commissioner and Secretary, Government of Assam, Revenue and Disaster Management. 03/01/2006.
Yes.
2002. 22. 2020. With reference to the letter subject cited above, I have the honor to furnish you with the report submitted by the Circle Officer, the Guwahati Revenue Circle, by letter number so dated 22/12/2021, in connection with settlement of land measuring so and so covered by Dag number 97 of village Ulugori under Ulugori Mauda in favor of Sri Arun Kumar Singh, son of so. It can be noted that the proposed land is not allotted or settled in the name of TB hospital. This is the letter from the Deputy Commissioner, Lordship. The proposed land has not been approved. Proposed land is not allotted or settled in the name of TB hospital as per hand records available, and the proposal has been approved by the SDLSC held on 11/12/2020 by resolution number so and so in compliance with the Honorable Guwahati High Court order dated 10/1/2022 passed in case number 292 of 2020. So they are telling the Deputy Commissioner himself, who is the custodian of the land in the Guwahati Revenue Circle, he himself has stated that the proposed land is not allotted or settled within the name of TB hospital. My learned friend is submitting that it has been settled with the TB hospital. Now the Deputy Commissioner is contradicting. once deputy commissioner is telling that it is not allotted to the settled with the TB hospital, and my learned friend, they are submitting that it has already been settled. Earlier it has been settled. And in 2022, the deputy commissioner himself wrote,
Now, this is an area of one Arun Kumar Singh,
Lordship,
one katha, five letter.
that number is same.
One
90
katha, five letter. That is the question which we are trying to ask. Whether the entire land covered by Dag number 97 is reserved for TB hospital.
So far, the deputy commissioner has written to the commissioner secretary that it is not in the record available. The proposal has, it is not settled with the TB hospital. The deputy commissioner himself.
That is what we are trying to ask you. By this letter, Deputy Commissioner has said that out of Dag number 97, one katha, five letter, which is the area concerning this incumbent Arun Kumar Singh, that is not reserved for or allotted to TB hospital. The question-
So other,
No, the question is this, is it projected by the department that the entire area covered by Dag number 97 is for the TB hospital or some part of the area?
entire area, entire area.
97 what is the area of Dag number 97?
9 bighas something.
9 bighas something. Yeah.
Huh?
9 bighas some area, or some. Sita is there.
This is a very pertinent question issue.
Absolutely, to which we have replied in our consolidated affidavit. But let him complete his submission.
No, we
This was-
just wanted to put, we'll come back to Mr.
Yes.
Dhar.
but this was
Whether the
complete-
entire Dag number 97 is,
Entire Dag number 97 is allotted. That letter issued by the district commissioner, my lord, it was erroneously
Oh,
issued.
that-
We have taken strong note of that. We have, my lord, recall that, my lord.
no, we just wanted to know whether
Yes. Absolutely.
that plea you can take, that whether some aberrations were there, somebody had given some benefit table to somebody
Yes,
at some point of time, those are different.
yes.
But if the matter was that some part, not the entire part of 97, then yes, that case would have been.
Then it
Yes.
it is our consistent stand all along, my lord, that Dag number 97, the entire area is reserved for TB hospital. This is also, my lord, fortified from the resolutions taken in the SDLS meeting.
Minutes of discussion পিছত দিছে আমাকে লোক minutes of discussion পিছত আছে
Minutes of meeting করে ফেলে, minutes of meeting.
ইয়াতে আছে ইয়াতে আছে
Yes.
Because on the earlier occasion, Lordship has directed us, my lord, to get the records ready. We have a complete team, my lord, six, my lord, in the corridors, my lord, we have with trunk loads of records, my lord.
Okay, yes, Mr.
Now, if your lordship comes to the affidavit filed by my learned friend, the annexure F, page 120,
120.
120. Just filed on 18th June 2025. Annexure F, page 120.
Yes.
This is the minutes of the meeting held on 19/2/2022. In Lordship, the date is important, Lordship, 21/2/2022. That minutes of the meeting which was held.
The nomenclature land of TB hospital. Dag number 2.
Yes.
Now, if your lordship comes to page 130 of my rejoinder, lordship.
Yes.
Page 130 of my rejoinder. Now, the minutes of the meeting was held on 21/2/2022. And the letter issued by the deputy sub-divisional officer in charge land settlement branch, Kamrup Metro District, Guwahati, letter addressed to the Commissioner Secretary to the Government of Assam Revenue with Disaster Management Department, Dispur Guwahati 6. It was of 17/3/2022. After 1 month of the minus of the meeting. Lordship got it 130. Bag number 90.
Yes.
Lordship got it 130, page 130 of my rejoinder. Minus of the meeting was held on 21/2/2022 at page 120 of their affidavit in opposition.
Yes.
At page 130, Lordship, letter dated 17/3/2022, which was written by the sub-division officer, Southern, in charge Land Settlement Branch, Kamrup Metro District, Guwahati, to the Commissioner and Secretary, Government of Assam Revenue and Disaster Management Department, Dispur Guwahati 6. With reference to the letter cited above, subject cited above, I have the honor to furnish here with the report submitted by the Circle Officer, Guwahati Revenue Circle, by number so dated 28/2/2022, in connection with settlement of land measuring 1.76 R, covered by Dag number 97 of village Ulubari under Ulubari Mauza in favor of Srimati Firuza Begum, wife of so and so. It can be noted that the proposed land is not allotted or settled in the name of TB Hospital as per hand records available, and the proposal has been approved by the SDLSE held on 11/12/2020, white resolution number so and so in compliance with the Honorable Guwahati High Court's order dated 10/01/2020. May be corrected as 10/6/2020 in case number 292 of 2020. So minus of the meeting was held on 21/2/2022. And this letter has been issued after 1 month, that is 17/3/2022, stating that this proposed land has not been allotted to the TB Hospital. How does what will be the answer of my letter in this regard, Lordship, after minus of the meeting? In the minus of the meeting, Lordship, the member present in the meeting discussed about the urgent need for a second medical college for better health and accessibility of the general public of the state. The nomenclature of the land of TB Hospital to be changed in the name of second medical college at Guwahati. It is the beyond the boundary of TB Hospital. These lands are beyond the boundary of the TB Hospital. Lordship. Outside the boundary of the TB Hospital.
What is this High Court order?
High Court order, Lordship, that is of 2020. It's passed by Mr.
It is 10/6/2020.
Where is it?
Lordship.
We had enclosed it in our consolidated affidavit, my lord. Lordship will find it from page 149 onwards.
Yes.
It starts, my lord, at page 146. Judgment, Lordship will find from 149 onwards.
This Firoza Begum was where in this case? We find that Arun Kumar Singh was there, petition number 1. Where was Firoza Begum?
Here's a Hamid Akbar is a. Looks like it to 962. It to 962. 962 আছে। It's to 962 আছে।
That was in Krishna, the group.
6. ঘুরতে লিখেছে বলে না।
Firoza Begum was not a petitioner in this writ petition, my lord. That writ petition.
962 আসলে 962 একটা রিপিটেশন আছে তাতে আছে।
In another repetition, 962. She was in 962 also, in WPC 962. There was another repetition lordship.
Where is it?
It's not a next lordship.
But
It's not a next lordship. In the
but the mention is of 292.
292 wrongly mentioned lordship.
They have probably আমি পার নাই তো এই লোকে করেছি।
It was the, this affidavit was filed by my land front also. 292 is wrongly in 962, no?
962
He was a repetition in 962.
order dated 28/6.
Order dated 28.
28.
The order was dated 28/5.
28.
Okay, now yes.
28/5/2020. Now this minutes of the lordship is in the minutes of the meeting
Yes.
held on 21/2/2022. And this
19-2.
letter was issued
Not
after
21 to 19 2.
minutes of the meeting.
Not 21 to 19 2.
92, minutes of the meeting was held on 19.
Yes.
And this letter was issued on 17/3/2022.
Yes.
So in this letter, it was categorically stated that it can be noted that the proposed land is not allotted or settled in the name of TV Hospital as per the hand record available, and the proposal has been approved by the SDLSC held on 11/12/2020. By the resolution.
Yes. This land means the land measuring
Measuring
1.76
R.
are okay. Yes. So is this the only ground that 2 persons were granted allotted land?
No.
Then what is your ground?
10% well.
10%. That is, no, some persons were granted.
Yes.
That is the only ground.
Yes.
No other ground.
Grounds are there, lordship. Lordship, whether the speaking order is a speaking order or not.
That you can elaborate.
Lordship.
94, page 94.
Page 94. Because the judgment which was passed on 7/11/2024, paragraph 15. Categorically states, may I read lordship. At page 69.
69.
69 of my writ petition.
Yes.
Accordingly, this court therefore disposes of the instant batch of these writ petitions with the following observation and direction. The imperial notice says under Rule 18 so issued to the petitioner to vacate shall be construed as notice issued by the circle officer Guwahati Revenue Circle to show cause why the petitioner should not be evicted by taking records of Rule 18 of the settlement rule. The petitioners in the present batch of writ petitions are given the liberty to submit individual replies and substantiating the same with documents and such evidence as deemed proper, thereby showing cause that the petitioner have bona fide claim of right involved in respect of the land under the petition. And as such, the recourse of Rule 18 of the settlement rule is not permissible. The liberty given above is to be exercised within 30 days, from the date of the state order. In the said replies, the petitioner herein shall indicate in which the the petitioners were parties. The Deputy Commissioner, Kamrup Metro is directed to give an opportunity of hearing to the petitioners either personally or through their authorized representative. The Deputy Commissioner, Kamrup Metro shall thereupon pass appropriate speaking orders. The Deputy Commissioner, Kamrup M, is further directed to allot a particular area in his office wherein such replies could be submitted. A notice be hanged in the office of the Deputy Commissioner, Kamrup M, indicating the area. The court further directs that upon the speaking order being passed, the Deputy Commissioner, Kamrup Metro shall notify in his notice board about the fact that the speaking order
Yes,
has been
yes,
passed.
yes.
So now, this is the speaking order at page 90.
Yes.
Here only it is stated that whereas an inquiry by the co-district commissioner, New Guwahati co-district concluded that the settlement petition of the petitioner is not acceptable as per the land policy 2019 and rules thereof. These 2 lines, 3 lines. That is what we are challenging, whether it is a speaking order or not. And Lordship is to decide whether this shall be the speaking order or not.
Uh, 19.3 is there? After hearing the aggrieved parties by the co-district commissioner had submitted a report on 19.3.2025. Have you annexed this report?
Yes. In our affidavit, it is, let him complete.
Now you can stay.
Now
Now,
you,
another friend is also-
Mr. Dhar, you want to contend
Yes.
that 26.3.2025 is not conforming to the requirement of a speaking order.
Yes, Lordship.
Kindly elaborate. What is a speaking order? What should it be? Are there any case laws? Are there any guidelines?
No. This honorable court is categorically directed. The petitioner to submit an application.
Now that we have
with
seen,
all legal-
you are saying that this is not a speaking order.
It's not a speaking.
So what is, what according to you is a speaking order?
The documents which we have submitted, that should be examined. We have to be heard.
Now that examination was done by the co-district commissioner.
That examination was done, whether that examination was actually done or not, that is what, Lordship. We have submitted, but
No,
we are,
the co-district commissioner's report 19.3 is also examined by the district commissioner. Now, is it required to have the form of a speaking order that it should be run into 5-6 pages?
but the documents which.
Or
we
is
have
it
submitted-
required that in brief, everything has to be there?
Lordship is
Even
correct.
a 10 page may not be a speaking order if it is all irrelevant things.
Lordship is correct.
We would like to see whether the relevant factors have been taken into consideration. It may be done in a brief manner. And it
Yes,
has
sir.
referred to certain reports.
Lordship is
Reports
correct.
were made after hearing you by the
Lordship.
co-district commissioner.
Lordship is very correct, Lordship, but the fact is remains is that.
Now, if you contend that this is not a speaking order, you have to convince this court that this is what a speaking order should be, and this is not conforming to
Look,
that.
What I am submitting before your Lordship is that the documents which we have submitted, that has to be examined first, and thereafter they should pass a speaking order. That documents were not examined, Lordship.
Where have you stated?
At page 14, para 13,
Page 14.
page 14, para 13.
Yes.
That in pursuance of the judgment and order oral dated 7/11/2024, the District Commissioner Kamrup Metro delegated the power to the respondent number 3 to take hearing of the applicant, present petitioner, and further to examine the documents furnished by the applicant as per observation and direction passed in Roman 4 and Roman 5 of paragraph 50 of the judgment and order dated 7/11/2024. The respondent number 2 by impugn speaking order dated 26/3/2025, which was received by the petitioner on 17/4/2025, by which settlement proposal of the petitioner was rejected. In the impugn speaking order, no grounds were cited as to why the claim of the petitioners were rejected as such the impugn shown. No grounds were cited, Lordship.
Yes,
The documents.
yes. You have
documents-
said the documents have not been examined. You have not even taken that plea. Speaking order talks about a report. Have you said anything about the report?
No.
Have you challenged the report?
Report we came to know well after filing of the affidavit of opposition by my lord.
But after hearing of the claims, the co-district commissioner has formed a report.
Lordship,
That was taken into consideration by the district commissioner.
that was taken with the district commissioner.
No.
That report was not
Now,
furnished.
you have said the documents are not examined. Where have you stated?
That is what, Lordship.
Where?
The petitioner was rejected, the impugn order has no grounds were cited as
No,
to
no.
the claim.
That is
The
different.
documents which were.
That is
furnished-
different. That is different.
The documents
Yeah.
which were furnished, that was.
Where have you stated the documents have
That
not been
that is
considered?
not there in the pleadings, Lord. But the report which was annexed by my Ladat was, we came to know about the report only after the filing of the affidavit of opposition. Therefore, we could not able to challenge that. Finance of the meeting.
In short, you say that the grounds are not there. And some other persons have been allotted land. in the
Allotted
same-
land.
That these are your basic,
Yes, Lord.
yes, anything you'd like to contend, you are also in the same footing. Which matters?
So
No, which matters?
item number 11. My lord.
Mr. Dhar, you are in which item? 2130. Other also. 12, 13, 14, 15,
26,
26, 27, 28, 29, 30, 31. Okay.
My lord, 7/11/2024. my
You
lord.
are in item numbers,
Item number 11.
only 11.
Okay. 6 to 4, hold on.
No, those were separated,
Yes,
not,
Master, 11, only 11.
not 6, 5, 7, 9, 10, only item 11.
My lord, item number 11, my lord.
2128.
Yes, my lord, 7/11/2024. This honorable has passed, my lord, stating that some guideline has been fixed, my lord, at the time of hearing of the petition, where we are the petitioner in this case, my lord. The main,
Justice Barua's judgment.
yes, my lord, Justice
Yes,
Bogor,
yes.
7/11/2024, my lord. I have already, he has already read, your lordship also knows very well, my lord. Then, my lord, on 19/11/2024, I filed a representation, page 76. I want to this, my lord, representation, my lord.
On when did 1911.
19/11/2024, I filed a representation before the authority. All the petitioner, I am taking only one, my lord. Page 76, my lord.
Presentation, okay.
Yes, my lord. I want to read this because, my lord, here's taken speaking order passed, report, nothing has been taken consideration of all these things, my lord.
Okay.
And as per I just now finding the Google's, my lord, speaking order means I can give the judgment, my lord, later on. That speaking order means you have to touch all the point which has been mentioned by this open. May I read, my lord, that, my lord, page 76.
76.
My representation
Yes.
before the deputy commissioner.
1911,
Yes, my
2024.
lord. My lord, I skip paragraph 1, my lord. Paragraph 2, my lord.
Yes.
Your lordship kindly come to the, my lord. Directly, my lord. Para T4 Kobula, my lord, 6. Page 78. that the applicant back to state the circle officer Guwahati has submitted a proposal in respect of the applicant to the regulator for taking necessary settlement land in favor of the aforesaid applicant. Subsequently, he was returned for applying the scheme of Bosundhara 2, then para 7. That the applicant back to state that earlier also before the year 2000, even after proposal was sent to hearing also take place, district administration silent over the matter. Apart from the circle officer had eviction notice dated 7/2000 Allah Firazar, having no other the applicant along with just so and so. I have mentioned about the case mail. Is a modern mom this. Let's kindly come to the para 11 mail.
11.
Yes, my lord. Page 18. That the applicant back to state that Government of Assam Department of Revenue has accorded approval on the same DAG number 97 for settlement of one Madan Mohan Biswas and other is Bankim Chandra Biswas. Accordingly, the
No, Mr. Chaudhary, just to cut things short, whatever has been argued by Mr. Dhar, you may not repeat.
What?
Madan Mohan Biswas, then Firoza Begum, we have taken into
Yes, my
consideration.
lord. I want to say something, my lord. I'm
Yes.
submitting, my lord. Madan Mohan Biswas, Bankim Chandra Biswas settlement has been given. The circle officer in the affidavit first said that it was given as per direction of the Honorable Court. Although there is no direction of the Honorable Court. Honorable Court has said that you verify if they are found valid. I am supporting Bankim Biswas and Madan Mohan Biswas in this case. If their proposal is valid, then you give the settlement. Accordingly verified, my lord, along with Arun Kumar Singh, my lord, and others, they said this DAG is not belongs to the TB hospital, 97, and correctly said, my lord, because in their additional, in their affidavit in opposition, there is an annexer, minutes of the meeting, DAG number 97 is not available, my lord. If you also go through all these things, my lord, 97, not there, my lord. And subsequently, they give the settlement to these persons, my lord, and validly settlement has, and patta has been issued to the Bankim Chandra Biswas and Madan Mohan Biswas, other patta were not allowed. My interesting thing is that, my lord, affidavit, two contradictory stand, which stand is correct, they have to stay, my lord. One stand is that as per direction of the Honorable Court, we verified all these things and settlement having given to the Bankim Chandra Biswas. I can show you that now, my lord. Subsequently, they have said, in respect of Arun Kumar Singh and other, that it was erroneously made the settlement and other, my lord. So, they will cancel for Arun Kumar Singh. But they are silent about the Bankim Chandra Biswas and Madan Mohan Biswas. Still on today, their stand is that it was validly made on the settlement. We are on the same footing, my lord. Everything is, my lord. My house is adjacent Bankim Biswas, Madan Biswas. There are one Muntu Kumar Bora in other petition, my lord, is adjacent. My humble submission before your lordship that if the benefit has been given to that, my lord, showing that like number 97 is not belong to them, my lord, why not it was given to me, my lord? That is my summary of the submission. I want to show something, my lord, that has been stated in para, my lord, 11, para 15 also I have, 12 also I said that land is outside the boundary of TB hospital. Then para 15, I have stated that the applicant based the claim of page 81. Claim of settlement 97 under the diagnosis, it may be mentioned here that your good office after examination of the entire record satisfied from the report submitted by Lat Mandal, para 15, page 81. And circular for a proposal was sent by letter dated 3/1/2022, Government Department, Revenue for according approval for the settlement of the aforesaid land in question in favor of the 2 or 3 co-villagers. In pursuance of the letter dated 3/1/2022, District Admin Government in the department so informed your very good office that the Governor of Assam was pleased to settlement measure are covered what is revenue circle co-villagers. It may be partly mentioned here that in respect of the 2 persons, namely Madan Mohan Biswas and Bankim Chandra, their respective land measuring 1/3 R, 150 have been settled by issuing patta and record have been corrected. Then, my lord, your lordship kindly come to the next, my lord, speaking of that, my lord. State court is a 218.
218.
Huh? 218, I am this. Yes, ma'am.
Yes, speaking order.
Another thing is that, my lord, there is a direction from this honorable, you hear the matter, or you can authorize the matter. That authority letter was not, my lord, produced before the court, my lord.
Is it required?
Is required, my lord.
Why?
Authority letter required because there is a here when he delegated the power, my lord. He
How
has
does it make any difference? Court has categorically said in paragraph 4,
yes, ma'am.
either by himself or by an authorized
yes,
officer.
ma'am. I
By
need
not
to
producing the authority letter, how what
First,
prejudice?
we have submitted to the deputy commissioner, my lord.
Yes.
Then, my
Court said
lord,
that either deputy commissioner or any
deputy
person
commissioner
designated
must be
by
here,
him.
my lord, that I am authorized so and so and to hear this matter.
If that is not before the court, the entire thing goes.
That is my submission, my lord. Yeah,
Not submit.
Speaking order, my lord. Annexure 10 is
Yes.
18. Because, my lord, in respect of my lord, other thing, my lord, National Investigating Agency, the notification.
That is the difference in a
Okay.
writ court and in the criminal proceedings or in a civil proceedings. You may insist on those,
In
but here it's not like that.
Yes, ma'am. Speaking order, where High Court, Honorable High Court find its husband petition has directed the district court to give an opportunity of hearing to the concerned person, Deputy Commissioner District Head, Co-District or New Co-District, Co-District or New Guwahati submitted report, where a disputed government land has been reserved for TB hospital and an applicant is unauthorized possession of land and submitted an application for settlement. Whereas inquiry by the Co-District or New Co-District Communal Settlement petitioner is not accepted as per policy to the rule thereof. Nothing is available, my lord, in respect of what I have submitted in my representation. Nothing has been said, my lord. Only said that is my rest he has submitted, my lord. And the word has been this honorable court has said appropriate speaking order. It should be appropriate speaking order, my lord. In that case, my lord. Now I want to go to the, my lord, affidavit concern. Their affidavit file in this case, my lord.
Okay. Page
Yes, my lord. I want to coming directly page 424, last page.
424.
Yes, my lord.
Yes.
They have stated, my lord,
This was stated, 19.2 has been
Yes, my lord.
placed.
My humble submission before Lord Chief, why the settlement have been given to the Bankim Biswas and Madan Mohan Bisada? Because that number
Well
97
considered it. That's
is-
a valid point.
that,
Consider.
that number 97 is not available in the minutes of the betting. That is why in year 2020, they have given settlement. Even 2022 also, they have stated all these things, my lord. That this number is not available, my lord. Suddenly, my lord, it isn't crop up that they say diagonal 97. And your lordship will look to that, my lord, column part. It was inserted by the record assistant. What is the report of Mondal, Sita record from earlier, my lord? Everything should be produced before this honorable court. Only 3 years, my lord, they have given the opinion of the record assistant during this petition, my lord. I want to show something, my lord. The lordship kindly also show the detailed report they have submitted, my lord.
Which one?
Is that page 373, Co-District Commissioner, which report has been submitted to the Deputy Commissioner, my lord. In my lord, affidavit in opposition, my lord. Filed by,
Yes, 373.
affidavit opposition, filed by respondent number 2,
373.
373.
No.
Where I read this thing, my lord. This is the same affidavit, my lord.
— 373.
Yes.
Not be 370. 370 is some
Here,
vernacular.
just one second, my lord. So, page below, ulta putta
Lordship will kindly come to 377. 377.
Yes, ma'am. 1 minute, both of you.
Yes, yes. 73. 73.
Correct, put them, huh?
73.
Yes, ma'am. 373. It is response to letter, your reference number subject, I have the honor to say Monmil Boro, so and so, consequently, the petitioner along with representative, they appear before the during the petitioner, represent the petitioner's statement of the Monmil Boro, so and so.
Where are you reading? This is of Santi Devi. 377,
373, I read.
373.
1 million, same, my lord, same, 373.
No, no, 373.
1 mil Boro.
374. I'm so sorry, my lord. 374. Some, my lord.
375, 1 mil.
Yes, yes. Ulta pulta hoyeche.
375, 1 mil.
Submission of detailed report.
1 mil.
connected
Yes,
to
yes,
the
ma'am.
expense.
In response of
375.
yes, madam.
Same date is same 13, 3.
Same, my lord.
In response letter reference number subject about a hearing the Monmil Boro Ramson Boro conducted undersigned 27. Consequently, the petitioner along with representative landed so and so. See, Monmil Boro is originally from Bijiguri, Soigao, Kamrup district. He came on what is started living disputed and land. They have ancestral property Soigao, but the exact amount is not known. The village also come not reflected. The authority portal. This is wrong statement, my lord. Because, my lord, if your lordship go to my statement, my lord, I am not reading. It was in vernacular, my lord. Although we are disputed that they have taken the signature blank. Even it is assuming, nowhere it is stated that there is a ancestral plot of land, my lord. He is in possession of quantum land measuring 0 biga 1 kotha 2 lesa. He filed Kobula 2000 on perusal of the remark 97 TB hospital. Land police state government will not consider statement land in Guwahati and other area possession of individual respective land. Section 14.3 land individual mayor possession of the land certain Guwahati city. The further as the government land is already reserved for public and they cannot be settled with the individual. It is settled at TB hospital for the second medical college hospital for the Assam. As such settlement also may not be considered. Whether he has stated about the Bankim Chandra Biswas, Madan Mohan Biswas, I file a representative that he may say, my lord, that this land is where he has mentioned in the my lord representation, this land not belongs to my lord TB hospital and other. Then they can get a different aspect of the matter. I have categorically stated, my lord, in my petition, my lord. And nothing has been said in the report as well as speaking order. So this speaking order has to go, my lord, my humble submission. I want to submit other thing, my lord. Same thing, my lord, other also, my lord. Your lordship will come in that, my lord. 422. Last bar, third page, my lord. Just before minutes of the looking, my lord. 422. কিমান আছে লাষ্ট আগত কিন্তু আমি ফিরে 422 মান
422 is the what? Chita?
yes my lord
Yes.
Yes.
it should be only for 3 years 23 24 25 they should produce the land record for 30 years but there's the consistent stand is that it is the land of TB hospital man note of land record assistant TB hospital Jumilekar Hoyaka Toka, TBA Certifica. Where how can my lord this report shall be given by the my lord land record assistant, my lord? He is not suitable person to give also. Then your lordship kindly come to the my lord. Itu like opportunity activities in the first time as a government business or retail. It will like it. Next episode. My lordship kindly come to the my lord, affidavit in my lord, reply. Additional affidavit filed by me, my lord. Page 318, my lord. It was filed on, my lord.
Yes, we've got 318.
Yes, my lord. Have you also got it?
After the judgment.
Yes, my lord, after the judgment.
Yes.
He has already said, my lord.
3/1/2022.
Yes, my lord. Yes, my lord. In respect of Arun Kumar Singh, the proposed land is not allotted settled in the name of this as per record available, and the proposal has been approved as DLC. L 111 filed resolution 293 in compliance of the Honorable High Court order dated 10/1/2000 WPC 292/2020. 2022-2023 said, I am not going to this matter, that you verify if found he is eligible as per land policy 2019, then settlement can be given to him, my lord. And accordingly, my lord, Arun Kumar Singh settlement has been granted, as well as, my lord, in that petition, Madan Mohan Biswas and Bankim Chandra Biswas also there, and they were issued patta, my lord. And my lord, patta has been, your lordship will find, page 320, funicular is page 321, my lord. This patta has been issued, Madan Mohan Biswas on 8/12/2021, my lord. My lord.
Page?
Page 321 funicular, translated is page 319, my lord. 319, my lord, and funicular, my lord. And accordingly, my lord, they have corrected the Jamabandi copy also, my lord. Your lordship will find page 324 funicular. Premium has been deposited, and accordingly, his name, new DAG has been stated. They have stated the entire DAG is TB hospital. Then how can this settlement reason? I am not there. Actually, I am submitting Madan Biswas. Actually, this DAG is not TB hospital. That is why Madan Mohan Biswas and Bankim Chandra Biswas were given settlement. And we are on the same position of Madan Mohan Biswas, Bankim Chandra Biswas. And their affidavit, they are silent about all these things, my lord. That is the thing, my lord. And now I come to the consolidated affidavit. এখন মই কৈ আছো
Page?
Page 140, my lord. That
140.
is in my, not my case, my lord. In other cases, consolidated file. ইয়াতো আনছে নেকি কথাটো?
Which, where is the consolidated?
Item number 12.
12.
Where is the Tutumani?
Tutumani.
Consolidated affidavit and in persons of order passed by this honorable court, we are
Yes, yes,
relying
sir.
for
Yes,
all
yes.
the cases,
Yes,
and they
correct.
have replied, my lord.
Yes.
Yes, yes, I মানি লৈছো তোমাক।
Consolidated page?
Page 140. Para 6, my lord. That the deponent back to state that certain proposal land measuring 1 and R and Ulubari under Guwahati Revenue Circle was accorded approval by the SDL.
Just a minute, consolidated affidavit.
Page 140, my lord. The 11th paragraph.
Just,
It was started from, my lord. 180. Where is it? 136, 135.
yes, 135 of,
Para 6, my lord.
para 6,
Yes, my lord.
page?
Page 140. You know, 140. Okay.
Yes, please read.
That the deponent back to state their settlement proposal land measuring 1.39 R originally covered by under DAG number 97 of village Ulubari under Guwahati Revenue Circle was accorded approval SDLC meeting held 11/12/2020 by resolution number 92. Accordingly, a set performance was forwarded Revenue Department Government Assam, so and so, so and so. Erroneously noted that the settlement has approved by the SDLC in compliance with the Guwahati High Court order dated 10/1/2000 passed in WBC 292. Subsequently, the Revenue Department Government Assam by order number dated has accorded approved settlement proposal submission of the copy of the recommendation of the GMDA. Accordingly, applicant had deposited settlement premium with due process of law. Circle Officer Guwahati Circle requested to hand over the possession and corrected the land record as per rule. Thereafter, Circle Officer Guwahati Revenue Circle finally handed over the possession and corrected Madan Mohan Biswas, creating this. The deponent had said the Honorable Guwahati High Judgment or order have nowhere directed to the right applied for should be settled with Madan Mohan Biswas. My lord, if your lordship go to the page 157, my lord. This is the settlement order, my lord. Of Madan Mohan Biswas. With reference to the, I have to go to
Page,
page 156, my lord, 156, 157, my lord. With reference to the above, I have to submit herewith land settlement proposal, Madan Mohan Biswas, son of late Bhattacharya, again following schedule. On careful perusal proposal submitted, the concerned officer found adhere criteria law laid down frame AL land policy. The applicant is settled for 20 years. It is 15 kilometers, so and so, so and so. I want to submit, my lord. Earlier day, I filed the affidavit, my lord, in my cases. This stand was not taken by them. Now, when your lordship has a contradictory, when this problem has been crop up, they know they are on fix. This affidavit has stand. This both the affidavit is in contradictory stand. I have stated, my lord. My humble submission before your lordship is that. To that, my lord, I have given a reply, my lord. Affidavit means.
no, Mr. Chaudhary, when they have stated
Yes, my
that
lord.
there was no direction of this court for settling the land in favor of either Madan Mohan or Bankim Chandra,
Yes, my lord.
what steps have been taken?
My lord.
Have this,
Now, earlier they have stated that this settlement was given, my lord, as per direction of the honorable court, my lord. And what is the direction of the honorable? I have annexed the order in that, my lord. If your lordship go through all these things, my lord, everything will clear. When the settlement has been given to them, my lord.
Mr. Borpuzar, you have said that the observation that there was some direction that was erroneously done because there was no such observation. Well, how do you justify the settlement?
There are materials on record, my lord. I will.
Yeah, I have justified the
Yes,
settlement.
yes, yes.
Is it on 97?
My lord, yes. Lordship will kindly come to page 144 of that affidavit.
Is it the same dark 97?
Yes, 97. Kindly see.
144 years, what is it? Yes.
Subject regarding cancellation of settlement proposal of
Yes.
Sri Arun Kumar Singh and two others.
No, Madan Mohan Biswas, I am submitting.
Yes, Madan
Madan Mohan silent, my lord. In my cases, I categorically stated point, he is silent, my lord. That is why I am submitting. This circle officer sometimes said X, sometimes said Y. That is my submission before your lordship, my lord.
Madan Mohan, these two gentlemen, my lord, Madan Mohan Biswas and Bankim Chandra Biswas, they were already given settlement. And on the purported, my lord, on the purported finding that there was a direction passed by this honorable court in a writ proceeding where it was categorically directed that you have to give settlement. We say in our affidavit that it was erroneously done, and we have placed on record the materials to suggest how it was erroneously done. I will justify, my lord.
Where is it?
My, I am reading the order.
Just a minute, just a minute.
Yes,
Where is
lord. Yes, lordship will kindly see, my lord. Lordship will kindly see
154 page, court direction.
the court order, my lord.
No, that is okay. Now just like you have taken some measures for Arun Kumar Singh, Shail Devi and Sunil Rajak,
Yes.
what steps have you taken for Madan and Bonkim,
Yes, therefore Lordship will kindly, my lord, first of all, come to page 146.
146.
146 is the judgment.
Yes,
It is WPC 292 of 2020.
right?
Lordship will find P2 is Madan Mohan Biswas.
Yes. Yes,
And Bonkim Chandra Biswas nowhere figures here amongst the writ petitioners.
yes,
Till my lord P11.
yes.
Then Lordship will kindly see, my lord, the operative portion, my lord, the dictum.
We have read that.
No, my lord, kindly see, my lord, I will have to. My lord, page 154, paragraph 14 onwards, my lord.
Yes,
The individual application made by the petitioners within a period of 1 month from today, and upon such applications being made, the Deputy Commissioner Kamrup Metro shall give a due consideration and pass reasoned orders after giving all opportunity to the petitioners for a hearing, and also produce any relevant materials that they may rely upon, and thereafter pass a reasoned order on the claim of bona fide right. This is just like, my lord, that Honorable Justice Borwa's, my lord, dictum. Depending on the order to be passed, consequential action to be taken. In the event no right is found, the petitioners to be evicted, and if any right is found, they may be allotted a suitable land as per the land policy. But that does not mean that they continue their encroachment over the government land. So, my lord, the directions were twofold. I have to give them a right of hearing. If I am satisfied, the authority is satisfied that they fulfill the requirements under the land policy, more particularly that they are landless person, then we will have to. There is no mandamus per se that you will have to give the settlement. Now, what the authorities have done, then I'm more police, so kindly, please. Now, what the authorities have done, Lordship, kindly come to page 156.
yes.
Because it is the district commissioner, I'm sorry to make this statement, it's the district commissioner at that point of time who created all mess of the things, my lord. Kindly see, my lord, this is, my lord, a communication, my lord, dated 15/7/2021. Lordship will kindly mark this, my. Madan Biswas and Bonkim Chandra Biswas. Page 157 is Bonkim Chandra Biswas.
Yes,
And page 156 is Madan Biswas.
Yes.
Lordship will kindly mark the common thread.
yes.
Bonkim Biswas and Madan Chandra Biswas are both son of Bateswar Biswas. Now, Madan Biswas is a writ petitioner in the writ proceeding, not Bonkim Chandra Biswas. Nonetheless, what the district commissioner has done, kindly see. Regarding, well, this is the communication from the district commissioner to the department. The subject regarding forwarding of settlement proposal in favor of Madan Biswas, with reference to the subject cited above, I have the honor to submit here the land settlement proposal in favor of Madan Mohan Biswas, son of late, against the following scheduled land. My lord, 1.3 are dark number 97. On careful perusal, the proposal as submitted by the concerned circle officer have been found to adhere to the criteria as laid down under the settlement rules framed under so-and-so land and relevant OMs there. No hearing took place, my lord, nothing, straight away settlement. They completely misconstrued, my lord. What had happened at that point of time? On extraneous consideration, I may not put that submission right now here, but the facts, my lord, the
No,
records
that
reveal.
is not the question. We are not on how you had
No,
gone
no,
ahead
the-
with Bonkim or Madan. We are on the aspect that just like you had initiated action against Arun and two others, what is the action you have taken so
Yes.
far as Madan and Bonkim is
Yes, the
concerned?
difference lies in the basic fact that by the time, my lord, they were already given settlement. They had already become partner. Now, this Arun and all the other persons, they had not given for final settlement. Their settlement was about to be given. At that point of time, we pull back.
Now, have you taken any action against Madan and Bonkim?
Modern and my lord, Bonkim so far, my lord, since they have already been settled,
No, have you taken?
albeit erroneously, my lord.
No. See, once you say that the entire land under dark number 97 is reserved for the TB hospital, which will now be converted to the second medical college.
Yes,
Now, no part of that land can be settled with anybody.
anybody.
Now, there are instances of aberrations that somebody has been given by taking advantage or by mentioning certain orders where there was no actual direction, and some other, so far as one Bonkim is concerned, there was not even an order.
Not even.
Order was there for consideration so far his brother is concerned, Madan.
Yes,
But that consideration has to be done for the land which is covered by DAG number 97, and as
97.
per you, 97 is meant for TB hospital.
TB hospital.
Now, second medical college.
Second medical.
Now, this has not happened some decades back. This has happened in 2021,
Twen-
for Madan and Bankim.
Yes, therefore, in our affidavit, my lord, prior to that, lordship will kindly peruse, my lord, my lord. What has been called out here, my lord. On careful perusal, the proposal as submitted by the circle officer have been found to adhere to the criteria as laid down under the settlement so OMs thereof. The applicant possesses the land by constructing personal residence since last 20 years. The plot of land is located in Guwahati Municipal Corporation within periphery of 15 kilometer. The land is not
We have
located.
read this and reread this.
Yes, no, lordship will kindly come see, my lord, the serial number 11.
11 also we have read.
Yes.
Reread, 10 times we have read.
So
Now
therefore,
the consideration done by the deputy commissioner is, it cannot be consideration at all because 97 is
Yes.
for, so what action have you taken?
action, my lord, no, because they have already been settled.
You cannot take any action.
My lord,
If it presumes, if it proceeds with the,
that is
on a
true.
wrong presumption
That is true.
altogether,
That is true. That is true.
the most important relevant consideration have been ignored or overlooked.
True. Only with regard to those, because by that time, my lord, we found out that this, my
This
lord,
97
error
is the
has occurred.
land for hospital, entire 97, why
Absolutely,
1.1?
absolutely, absolutely. This was absolutely wrongfully done. And we have stated in our affidavit that it was erroneously done. At paragraph, my lord, kindly see, my lord, at paragraph number 6, my lord. It is 140, if I may read it, my lord. The deponent begs to state that the settlement proposal of land measuring 1.399 originally so and so was accorded approval by the SDLSC meeting on so and so. Accordingly, the said settlement proposal was forwarded to the Revenue and DIN Department from the office of the so and so, wherein it was erroneously noted that the settlement proposal has been approved by SDLSC in compliance of Honorable Guwahati High Court order dated so and so, so and so. There was no approval by the SDLSC. There was no approval, but it was erroneous. In fact, it has been highlighted. Kindly see the error that has been done at that relevant point of time, my lord, at page 156, as well as page 157. These are our authorities, my lord. I'm sorry to make that statement.
Has been approved. And they have not stated in the affidavit that actually this was not approved. Only one erroneously.
No, erroneous.
They have, that is why I am submitting before from the first point, I mean, representation, I have stated all these things. Speaking on the report, nothing is available, my lord. All these things. Nothing is available, my lord, in the report. So, my humble submission before your lordship.
It has been put in bold. I will justify, my lord.
Just, which
Completed
part,
submission.
page?
Page, my lord, 156 and 157 are the two communications.
Yes, we have seen.
Yes, now lordship will kindly see, my lord, paragraph 6 at page 140. Paragraph 6 at page 140 of the affidavit. That affidavit, my lord.
Yes,
In the middle, my lord.
yes, erroneously noted.
Erroneous, lordship will kindly mark that.
Yes, I've seen this.
Yes, and at paragraph 7, so far as, my lord, the next person is concerned, my lord, Banking Biswas. We have also made that similar statement, my lord. Kindly see, my lord.
Yes.
Paragraph 7 in the middle, erroneously noted.
Yes.
Now, therefore, my lord, only these two documents at page 156 and 157, my lord. These are the only two documents, my lord, available on the record in the entire batch of writ petition, where, my lord, apparently the error was committed by the collector. Because the collector is the authority who sends the proposal. And the department will necessarily, my lord, will believe, my lord, to be as gospel truth. Now, where are the materials? Lordship, therefore, it was last So in the last part of these two communications, it has been written in bold. The proposal was duly placed in LGLSC and so-and-so, the so-and-so. Proposal was approved in compliance of Honorable High Court. This Honorable Court directed the authority to give them the right of hearing, and after.
Okay,
they-
now that is clear.
Similarly, my lord, Honorable Justice Borua's order, my lord, similar, the tenor is same, but this is the illegality. I have to, my lord, admit that this is the illegality.
Yes, anything else,
that-
Mr. Chaudhary?
Yes.
My humble submission before your lordship, my lord, today when it was come up in the hearing, they have stated all this. My humble submission before your lordship, one who seeks equity must come with in the first instance, my lord. First affidavit, they have known all these things because affidavit has been filed after verifying the record. And my additional affidavit has mentioned about the Bankim Chandra Biswas, Madan Mohan Biswas. My representation said Bankim Chandra report is nothing, speaking order is nothing. My first affidavit, in consolidated affidavit, when they are in trouble, they said all these things, only one word, you know, you also rightly said, what has been taken step to taken against them? Nothing has been done to taken against them, my lord. And because, my lord, it is a, my lord, 97 dark, their minutes of the meeting said 98. 97 is not available, my lord. So considering this aspect of the matter, your lordship pass necessary order, my lord. I shall nothing for my lord. And one thing is that, my lord, one judgment, important judgment, this,
please.
all the process which has been gone cannot come under the settlement rule, and it is comes to the Public Premises Eviction Act. Moment here they have stated, my lord, they stated it was allotted to the TB hospital. There is a division bench judgment of our High Court that they should to go to the Public Premises Eviction Act, and 18 notice has been set aside. So that they are allowed. I'm given one judgment, my lord. I leave it to your lordship. Yeah, I sir. I am given on WA 335 2018. 335 2018. This is the, my lord, eviction of Masqua Market. They have stated, my lord, earlier it is a government land. Subsequently, they have submitted before the court that it is a land of handloom and textile. I am not going to the facts of the case, my lord. I am only
Order dated?
order dated, my lord. I have given, my lord.
No, it's not there.
Yes, my lord.
You,
Order dated 3/12/2019, my lord. Division bench. Comprising
WA,
Yes, my lord.
335.
Your lordship is the what is this? On some that a reading of rule 18(2) settlement rule regulation shows that basic requirement invoking rule is the person sought to be acted as no bona fide claim, a right claim is present. The very there is no bona fide right to show entry of such respect plot of land with legitimate manner. In other words, condition precedent 18(2) settlement rule would not person who sought to be evicted exercise 18(2) possession land in illegitimate manner. From the point of view of factual metric, the present appeal, we have consolidated noted that respective applicant entered the plot of land through an instrument by the different department, government of Assam, hand entry or respective plot law cannot be either legitimate or to have been in accordance with law. In another aspect of the purpose, we are in possession was in another aspect of the course of time, the purpose for which they were put in possession was over. Perhaps they are no longer entitled to remain further possession of the land. If so, remedy responding authority evicting would not be under 18(2) settlement rule regulation, but it may be other provision of law. Accordingly, we interfere the process of eviction respondent rule 18(2) settlement rule under regulation, but however providing liberty respondent authority to proceed eviction appellant in accordance with law. Assam Public Premises Eviction Act, my lord. The lordship kindly come to this date, my lord. Okay. Yes, my lord. If your lordship go to the 3(4), I am reading, my lord. Assam Public Premises Eviction or Unauthorization Act.
Chaudhary, the immediate response is that you have allowed the judgment passed by Justice Barua to attain finality.
I am not. Recently, I was saying these things.
No, that is not the part of challenge. Prior to the, in terms of that, you had filed your reply. Now, can you go back and say
Yes,
that that
my
act is not
In
applicable?
my additional,
That will not, this will not be available to
Yes,
you.
my lord. I am stated in my
You
additional.
may, this may be a very good point,
Yes,
but
my lord.
Much water has
In
passed already.
additional affidavit, I take this permit.
Yes, anything we have understood.
3, 4, 5, my lord.
Huh?
Yes,
No,
yes,
it's
there
okay.
is
Yes,
the-
anything.
My lord, I will have to draw my lord's attention to the annexure.
Okay, we'll, but we have more or less understood. Your part has also been almost covered.
I will at least seek an accommodation for half an hour, my lord.
Not half an hour, not required. We have understood your case. 10-15 minutes will be enough. We have gone through everything. Only important point you can touch upon. Okay, 2 o'clock.
Only one aspect of the matter that they have
Now,
completely
if you
left.
think that there's something which is not covered, you can definitely address. But more or less, we have understood.
They have
Let's
no-
see, with their main contention is first that there has been discrimination. Qua, Madan Biswas, Arun, and so you have against Arun and 2 others, you have taken action. Against Madan and you have not taken any. They have said that in the minutes of meeting, there is no reference to any 97
There is
belonging to
altogether a defined minutes of
the-
meeting.
the
Yes.
different,
I'm satisfied.
They have an
and yes, and the allotment to this Arun and all were do stated to be as per court's order. There is no direction for doing that part. You have also accepted, and on the aspect of speaking order, they have addressed. You can make your submission.
Absolutely, absolutely.
It
But
is
what
not-
about their individual contentions?
But few parts we have not
Yes.
immediately that not producing the delegation power, that authority letter, those we are not on that. But whether it's a speaking order, whether the report has taken into consideration the relevant factors, whether their cases have been properly considered, that is what.
The most vital aspect of the matter, my lord, that I am not an encroacher. I have to satisfy. I may lay so many, my lord, defense that discrimination is there. that
Okay,
is
which,
not there.
which, let us,
Yes, but that
which case would be which of these cases will be relied upon? 121 to 2130?
Yes, my lord, item number 11 and 12. I will address my lord. only-
2130.
Yes,
Okay.
11 and 12, because
Okay,
in
no
item
problem.
number, my lord, 12, we have filed our consolidated.
Yes,
Well, item number 4 may be taken up any other day, my lord.
4.
Yes, my lord.
No, not any other.
My lord,
These are the series matters. We cannot segregate. We are completing. Only 5, 6, 7, 8, 9, 10, 16, 17 we'll be taking on Wednesday.
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 The 4 is not connected with the series.
4 is, my lord, forest department was not available.
Oh,
so
oh, forest. Oh, 4 is different.
Yes, but
Yes, forest. Anyone?
may be taken in any other day.
Okay, we'll have. This will finish within 2:30.
Well, may I crave your lordship indulgence, my lord. Item number 35, can it be taken up on any other day, my lord? Today I have some slight inconvenience, my lord.
34 what matter? Would matter of which year?
13.
13 matter. Unless you have some extreme urgency, you're going somewhere else.
Day after tomorrow, my lord, not, I am not.
Day after tomorrow. Okay, day after tomorrow, 13.
My lord, 4 may be day after tomorrow.
Okay. Noted.
Please, one thing about item number 39. Malad, I have to go home. Malad. Today is the day, Malad. I have to return back. 39 can be on next Tuesday, next week.
Other side,
Malad, government is there. Malad,
39 will have some other.
Malad.
Lordship may be pleased to take up the item number 12, my lord. 11 and 12, my lord, I will.
2139, 2130.
2130, my lord. And so like.
ये कोথায় রে?
15 minutes. and then go. Wait, no.
Before
Yes.
my learned starts, may I submit your lordship?
Yes.
In this case, your lordship,
Yours is which item number?
I am on item number 13, 14. Same, similar items, all same.
13 and 14.
13, 14.
You have anything else to
Yes, your
add?
lordship. I want to cite some judgments, Your Lordship. And prior to that, the land policy 2019, Your Lordship, may kindly please.
Then Bobijari is, let him complete this side, then.
Yes, my lord.
Land policy. Sir, land policy 2019, Your Lordship, may kindly peruse the land policy.
There is for item numbers, please give the repetitions number.
Yes, Your Lordship. WBC number 2198 2025.
2198 25. And
Really sorry, Your Lordship. WBC 2194 2025.
2194.
2025. I will give the citations, repetition numbers later on. Your
Okay,
Lordship.
two matters you are appearing.
5 meters, Your Lordship.
5 matters. Okay, please give the numbers.
Yes,
Okay.
sir.
Okay. What is your case?
The 14 point similar matter, Your Lordship. 14, Your Lordship, may kindly peruse land policy 2019.
Yes.
14 point 14.1, Your Lordship. Settlement and reservation of land in towns, 14.
14.
Your Lordship.
Yes.
No land within, may I read, Your Lordship?
Yes, please.
No land within municipal corporation or any town constituted under Assam Municipal Act 1956 or town land declared under the Assam Land Revenue Reassessment Act 1936 or the Assam Land Revenue Regulation 1886 shall be settled for agricultural purposes. 14.2, an indigenous person who has no homestead land in his name or in the name of his family in the state may be eligible to get land in Guwahati city or in the urban area, provided that such person is required to reside in Guwahati city or in that urban area by very nature of his occupation service, provided further that he has sufficient grounds to justify that he has not been able to purchase land in Guwahati city, town, city and other towns. 14.3, the state government will not consider settlement of any government in Guwahati city or in other town areas under possession of individual or other person merely on the ground that the person concerned is in occupation of such land irrespective of the period of such occupation or encroachment. It would be the policy of the state government to consider settlement or to evict such persons as the case may be. So it is provided, Your Lordship, that the land may be settled. However, it is also provided in the 14.3 that it is not, it has to be a policy decision. Then 14.4, however, in view of the land policy 1989, the other government decisions prior to adoption of land policy, the case of indigenous and landless person if found eligible and who have been under continuous occupation of government land since or prior to 28 June 2001 may be considered for settlement of maximum 1 katha 5 lecha of land in case of Guwahati and 1 katha 10 lecha of land in case of other towns as one-time measure for homestead purpose if they apply for it, irrespective of having land in rural areas subject to realization of the due premium. Now, in my case, Your Lordship, we do not have any homestead land and neither we have any land in our rural areas. Then Your Lordship may kindly peruse the land revenue manual. Assam land revenue manual, Your Lordship may kindly peruse. Land revenue manual.
Yes.
Yes. 12, Your Lordship.
Rule or regulation 12?
Regulation 12, Your Lordship. Power to make rules for the disposal of government land and ejectment therefrom of unauthorized occupiers.
Regulation 12.
12, Your Lordship. The Assam Land and Revenue Regulation 1886, 12, Your Lordship.
Yes.
Power to make rules for the disposal of government land and ejectment therefrom of unauthorized occupier. In the case of any land over which no person has a right of proprietor, landholder, or settlement holder under this regulation, the state government may make rules to provide for the disposal by way of grant, lease, or otherwise of such land. So the word otherwise in my respectful submission, Your Lordship, they may, Your Lordship, consider our case and give us settlement. Since we have been in possession for a long period of time, Your Lordship. Then, Your Lordship, 14.8.
Now, this is only for making rules.
Yes, sir.
It's an enabling provision for making rules.
True.
This by itself does not vest the power to consider. Rules can be considered. Rules can be framed.
True.
What is your submission that under the policy of 19?
Exactly, Your Lordship.
And,
Under the land policy 2019, our cases may be considered, Your Lordship. They have not done that. And one more aspect, Your Lordship, I'm relying on the judgments of the Supreme Court in Olga Telis. Prior to that, Your Lordship, Olga Telis, as Your Lordship is already aware, Olga Telis, Your Lordship. So, Olga Telis is AR 1986, Supreme Court 180, Your Lordship.
see, pavement dwellers and you, are you at par?
No, in my respectful
La-
submission, Your Lordship. yes-
Livelihood of by pavement dwellers, the vendors
Yes, Your Lordship.
in the Bombay case,
Yes, Your Lordship.
are you at par? There, the principle was that expanded meaning was given to 21,
Exactly, Your Lordship.
not just animal existence.
Exactly, Your Lordship.
Here,
Because
okay.
in this case,
Oh,
also-
which one? Which paragraph of Olga Telis?
Olga Telis, and then DAPENIS.
40.
Hmm?
Your Lordship, may-
Para?
Paragraph, Your Lordship, I'm reading from paragraph, I'm reading from 27, 29, Your Lordship. From 29 to 58, Your Lordship, 57.
All the paragraphs you
All
not
the
read.
paragraphs, Your Lordship.
No, no, you read the principles of law,
Yes, Your Lordship.
that right to livelihood is made
Yes,
a
Your
part
Lordship.
of
Then
21,
paragraph 57, Your Lordship.
57.
Property part, to may I read, Your Lordship. To summarize, we hold that no person has a right to encroach by erecting a structure or otherwise on footpaths, pavements, or any other place reserved or earmarked for public purpose, like for example, a garden or playground, that the provisions contained in section 314 of the Bombay Municipal Corporation Act is not unreasonable, and in the circumstance of the case, and that the Kamras Nagar Basti situated on an accessory road leading to the Western Express Highway. We have referred to the assurances given by the state government in its pleading here, which we repeat must be made good. Stated briefly, a pavement dweller who were censused or who happened to be censured in 1976 should be given, though not as a condition precedent to their removal, alternate pitches at Malavani or at such other convenient place as the government considers reasonable, but not further away in terms of distance. Slum dwellers who were given identity cards and those dwelling were numbered in 1976 census must be given alternate sites for their resettlement. Slums given alternate sites for their slums which have been in existence for a long time, say for 20 years or more, and which have been improved and developed will not be removed unless the land on which they stand or the appurtenant land in who is required for public purpose, in which case alternate sites or accommodation will be provided to them. The low income scheme shelter program, which is proposed to be undertaken with the aid of World Bank, will be pursued earnestly, and the slum upgradation program under which basic amenities are to be given to slum dwellers will be implemented without delay. In order to minimize the hardship involved in any eviction, we direct that the slums, whether it's situated, will not be removed until 1 month after the end of the current monsoon season, that is until October 31, 1985, and thereafter only in accordance with this judgment. If any slum dweller is required to be removed before that date, parties may be applied to this court. Pavement dwellers, whether censured or uncensured, will not be removed until the same date, this October 31, 1985. So my respectful submission, Your Lordship, is that we are also on the same footing, Your Lordship. The bona fide right of claim that has been directed to be proved by us, it's not there, because, Your Lordship, we are admittedly in a plot of land which belongs to the government. So it is very difficult for us to prove the bona fide right of claim, Your Lordship. But the only thing is that if we may be given alternate accommodation, Your Lordship, because we have been living there for a long period of time. In this case, Your Lordship, I'm also relying on another judgment. Ahmedabad Municipal Corporation versus Nawab Khan Gulab Khan, AR 1997, Supreme Court 152. Paragraph, I'm relying on paragraph 11, Your Lordship. May I read, Your Lordship?
Para 11.
11, Your Lordship.
Yes.
Article 19(1)(e) accords right to residence and settlement in any part of India as fundamental right. Right to life has been assured as a basic human right under Article 21 of the Constitution of India. Article 25(1) of the Universal Declaration of Human Rights declares that everyone has a right to standard of living adequate for the health and well-being of himself and his family. It includes food, clothing, housing, medical care, and necessary social services. Article 11(1) of the International Covenant on Economic, Social, and Cultural Rights lays down that the state parties to the covenant recognizes that everyone has the right to standard of living for himself and his family, including food, clothing, housing, and to the continuous improvement of living conditions. In Sameli Singh versus State of UP, 1996 to SCC 549, a bench of 3 judges of this court had considered it and held that the right to shelter is a fundamental right available to every citizen, and it was read into Article 21 of the Constitution of India as encompassing with its ambit the right to shelter to make the right of life more meaningful. In paragraph 8, it was been held thus: in any organized society, right to life as a human being is not ensured by meeting only the animal need for man. It is secured only when he is assured of all facilities to develop himself and is freed from restrictions which inhibit his growth. All human rights are designed to achieve this object. Right to live, guaranteed in any civilized society, implies the right to food, water, decent environment, education, medical care, and shelter. These are the basic human rights known to any civilized society. All civil, political, social, and cultural rights enshrined in Universal Declaration of Human Rights and conventions or other under the Constitution of India cannot be exercised without these basic human rights. Shelter for a human being, therefore, is not a mere protection of life and limb. It is home where he has opportunities to grow physically, mentally, intellectually, and spiritually. Right to shelter, therefore, includes a adequate living space, safe and decent structure, clean and decent surrounding, sufficient light, pure air and water, electricity, sanitation, and other civic amenities like roads, etc., so as to have easy access to his daily evocation. The right to shelter, therefore, does not mean a mere right to roof over one's head, but right to all the infrastructure necessary to enable them to live and develop as a human being. Right to shelter, when used as an essential requisite to the right to live, should be deemed to have been guaranteed as a fundamental right. As is enjoined in the directive principles, the state should be deemed to be under an obligation to secure it for its citizens, of course, subject to economic budgeting. In democratic society, as a member of this organized civil community, one should have permanent shelter so as to physically, mentally, and intellectually equip oneself to improve his excellence as a useful citizen as enjoined in fundamental duties, and to be useful citizen and equal participant in democracy. The ultimate object of making a man equipped with a right to enable him to develop himself into a cultured being. Want of decent residence, therefore, frustrates the very object of the constitutional enumation of right to equality, economic justice, fundamental right to residence, dignity of person, and right to live itself. Socioeconomic 11 is socioeconomic justice, equality of status and opportunity, and dignity of person to foster the fraternity among all the sections of the society is an integrated Bharat is the arch of the constitution set down in the preamble. Articles 39 and 38 enjoins the state to provide facilities and opportunities. Article 38 and 46 of the constitution enjoin the state to promote welfare of the people by securing social and economic justice to the weaker sections of the society, to minimize inequalities in income and endeavor to eliminate inequalities in status. In this case, it has held that to bring the Dalits and the tribes in the mainstream of national life, the state has to provide facilities and opportunities, as it is the duty of the state to fulfill the basic human and constitutional rights to residence, so as to make the rights to life meaningful. In Santistar Buildings versus Narayan Kimal Totome, 1991, SCC 520, another bench of these judges had held that basic needs to men have traditionally been
But this is
accepted.
okay, this, you need not read the entire thing. Okay.
On the last paragraph, if your lordship may kindly allow me, last part.
Paragraph?
On this paragraph, in the next page, 159, your lordship.
159. Yes.
Starting from the last 4 line, your lordship. From the last.
Right to livelihood.
The deprivation of the right to life, yes, your lordship. The deprivation of the right to life in that context would not only demand right of effective content and meaningfulness, but it would make life miserable and impossible to live. It would therefore be the duty of the state to provide the right to shelter to the poor and needy and weaker sections of the society in fulfillment of the constitutional objectives. So in my respectful submission, Your Lordship, it is a admitted fact that we have been staying in government land, but the question that I'm putting myself, Your Lordship, is that they have been staying there for the more than 20 years and the government has not done anything. After a period of 20 years, when they have been living there with their families, one finds that the government comes and they have a notice that they should be evicted. Where will we go, Your Lordship? My respectful submission at this stage, Your Lordship, is that we should be given alternate arrangements. If we are given alternate arrangements, Your Lordship, my instructions are very clear. We are ready to move from that place, Your Lordship. Until and unless we get an alternate arrangement, it's very difficult for us to move around, Your Lordship. That is my only respectful submission. Because bona fide right of claim we cannot have, right? Okay, that's my position. Another judgment, 2000, Chamili Singh judgment is also there, Your Lordship.
That has been referred in.
Yes, it has been recorded.
Nawab.
Yes, it has been recorded.
Yes. Give the numbers.
Yes, Your Lordship.
Yes.
No, so may kindly take up, my lord, item number 12, my lord.
2130.
2130. There will also be pleased to come to our affidavit, my lord.
Which affidavit?
My lord, to the affidavit in opposition, my lord, it starts from running page number 97.
Yes.
Here we have also filed an additional consolidated affidavit pursuant to the queries made by, because that discrimination has been pointed out. But as of now, my lord, I will be drawing my lord's attention to this affidavit, my lord. Lordship may be pleased to come to page 106, my lord, Annexure 8. How the authorities has conducted the hearing in pursuance of the dictum passed by this honorable court in the earlier round of litigation, those 5 conditions, my lord.
Yes.
Precisely, my lordship will come to page 107. That is the photocopy of the original, my lord, statement recorded, my lord. Her signature is also there. The writ petitioner originally was, my lord, one Sri Minal Hazarika, who had expired in the meantime. So therefore, my lord, his wife, Tutumoni Hazarika, is before this honorable court. Page 107. Now this has been recorded, hearing of settlement petitions. Possible, I am reading it, my lord. Reside, my lord, name Tutumoni Hazarika, wife of late Minal Hazarika, residing in disputed land since 1993. Tutumoni Hazarika is originally from Golaghat. Her husband Minal Hazarika was from Bhatizan Roha. They came to Guwahati in 1987 and started to stay in rented house. Then in the year 1993, they started to live on the disputed land. Minal Hazarika worked in irrigation department and he died in the year 2024. In her family, she and her son lives with her sons. Status of possession, 14 lesser of land, Assam type house. Status of Kabula petition down below, lordship will find Kabula filed in the year 2020. Now thereafter, my lord, page 108 and 109 are the translated copy of the statement recorded. A detailed statement, detailed hearing had taken place, my lord.
Yes.
If lordship may be pleased to come to page 110, I am reading the vernacular, my lord. 110.
Yes.
মই শ্ৰীমতী টুটুমণি হাজৰিকা স্বামী মৃত মৃণাল হাজৰিকা আজি 17/2/2025 ইংৰাজী তাৰিখে সমজিলা আয়ুক্ত নিউ গুৱাহাটী সমজিলা মহোদয়ৰ সন্মুখত উপস্থিত হয় সজ্ঞানে সুস্থ শৰীৰে জবানবন্দী দিওঁ যে মোৰ স্বামীৰ ঘৰ ৰহা আৰু মোৰ পিতৃৰ ঘৰ গোলাঘাটত আছিল। মোৰ স্বামীয়ে ইৰিগেশ্যন ডিপাৰ্টমেণ্টত কেৰাণী হিচাপে কাম কৰিছিল। মই 1987 চনত তেখেতৰ লগত বিয়া হৈ গুৱাহাটীলৈ আহিছিলোঁ। কিছুদিন ভাড়াঘৰত আছিলোঁ যদিও 1993 চনত উলুবাৰী মৌজাৰ উলুবাৰী গাঁৱৰ বৰ্তমান 97 নম্বৰ দাগৰ 17 লেচা খালী চৰকাৰী জমি পাই মোৰ স্বামীয়ে দখল কৰে। 1993 চনৰ পৰাই মোৰ স্বামীয়ে মাটিৰ খাজানা আৰু GMC টেক্স পৰিশোধ কৰি আহিছিল। তেতিয়াৰ পৰা আজিলৈকে এই জমিতে মই মোৰ একমাত্ৰ ল'ৰাৰ সৈতে অসম আৰ্হিৰ ঘৰ সাজি বসবাস কৰি আছো। বহুত আগৰ পৰা মোৰ স্বামী মধুমেহ ৰোগত আক্ৰান্ত হৈ তেওঁ দুয়োটা কিডনী বিকল হৈ গৈছিল আৰু ইংৰাজী 18/3/24 তাৰিখে তেখেতৰ মৃত্যুবৰণ কৰে। 2010 চনত আমিও গাঁওবাসীৰ লগত উচ্ছেদ জাননী পাই আমি উচ্চ ন্যায়ালয়ৰ দ্বাৰস্থ হৈছিলোঁ। উচ্চ ন্যায়ালয়ে উপযুক্ত মহোদয়ক আমাৰ আবণ্টন বিবেচনা কৰিবলৈ নিৰ্দেশ দিয়ে। Now, these are, my lord, the subsequent statements. Then lordship will kindly see, my lord. The fact that the land has been encroached upon by her husband is admitted. Then page 1112, this is the report of the co-district commissioner. How the authorities have recorded the findings. To the district commissioner, submission of detailed report in connection with settlement of land in favor of Sri Minal Hazarika, son of Letson, your good faith. In response to the letter under reference subject, I have the honor to inform you that in pursuance of your letter so and so, the Tutumani hearing of the concerned party, Tutumani Hazarika was conducted by the undersigned on 17/2/2025, as her husband has already died in the year 24 as per her statement. Consequently, the petitioner, along with her representative, learned advocate, had appeared before this end. During the hearing, the petitioner representative of the petitioner were heard, and the statement of the petitioner was recorded, copy and close. Now, these are the findings, my lord. Tutumani Hazarika was originally from Golaghat district. Her husband is also originally from Roha, Nagaon district. After marriage, she came to Guwahati since the year 1993. She is in possession of a quantum of land 14 where she had filed Kabula in 2020, but the same has not been placed in the SDLSC. On perusal of the Sitha remark of DAG number 97, so this is of paramount importance. On perusal of the Sitha remark of DAG number 97 of village Ulubari, Mouza Ulubari, it is seen that the land under dispute is reserved for TB hospital. Section 14.3 of the Land Policy 2019 states that the state government will not consider settlement of any government land in Guwahati city or in other town areas under possession of individual or other persons merely on the ground that the person concerned is in occupation of such land, irrespective of the period of such occupation or encroachment. It would be the policy of the state government to consider settlement or to evict such persons as the case may be. Then turning to the next page, my lord. The section 14.3 of the land policy clearly envisages that mere possession of a government land for a certain period of time in Guwahati city does not guarantee settlement over the land, and that the settlement is purely the discretion of the state government. Further, as the government land is already reserved for a public entity, that is TB hospital, it cannot be settled with individuals. It is also pertinent to mention here that the land of TB hospital has been proposed for the second medical college of Guwahati, that is Pragjotispur Medical College and Hospital. Hence, this government land is very essential for the greater public interest of the people of Assam. As such, the settlement application of the petitioner may not be considered for settlement. Now, this was forwarded to the district commissioner. Accordingly, the district commissioner has passed the speaking order, which lordship will find in the very next page, my lord. That lordship has seen, my lord. Page 114.
Yes.
Page 114 down below, after having recorded the reasons. Therefore, in view of the above, the settlement petition of Minal Hazarika Swainsa rejected and disposed of. The circle officer Guwahati Revenue Circle is directed to take further necessary action in accordance with law. Thereafter, the eviction process will follow as per the dictum, because a bidding period was to be given to them. Now, my lord, during the bidding period, the authorities had committed a mistake. Further 30 days period was to be given, were to be given to them. In the event they would like to agitate the speaking order. That was not given, and that notice dated 11/4/25, which lordship has seen in the morning hours, my lord, that was recalled. And that lordship will find at page 115, Annex D. Authorities will, lordship will kindly mark how the authorities are acting bona fidely. to Minal Hazoika with reference to the subject cited above, I would like to inform you that the above mentioned eviction notice, that is 11/4/25, was inadvertently issued in person to order. Therefore, the above mentioned notice is hereby recalled with immediate effect. The authority reserves its right to issue fresh eviction notice in due course of time. In the meantime, my lord, these writ petitions came to be filed, and this honorable court in the interim has granted them protection, my lord, interim protection. Therefore, my lord, no fresh eviction notice have been, my lord, issued. And page 117, lordship will see, my lord, this is the report of the Jari Karok, my lord, that these notices have been duly served. Tutumani Hazoika has signed it.
But this notice was already withdrawn.
We don't. We are acting bona fidely, my lord. We are strictly going by the parameters set out by this honorable court. Then lordship will kindly see, my lord, page 119. That is the chitha.
Yes.
This is the vernacular. My lord, in the left-hand column, lordship will kindly see, my lord, dark number 97. Then, my lord, Prothom Bosti, total land measuring, my lord, 38 bigha, 4 kotha, 12 lesser, 12.37 lesser. This is the total quantum of land. 34 bigha, 4 kotha, 12.37 lesser. Sorkari. It is government land. Then lordship will kindly see the Mottobya in the extreme right-hand corner. Bhumilekho Sahayakor Tuka, TB Chikitsalaya. That is why we are saying, my lord, that this land is reserved for TB hospital. It still retains the character of a government land, but it is reserved for public purpose, as has been laid down, my lord, in Rule 18. If a land is reserved for public purpose, because Rule 18 speaks of land reserved for public. I will come to that, my lord. I will read out that provision. Now, it is the settled position of law, my lord, that the revenue records and the entries made therein will be presumed to be correct unless and until the contrary materials are proved. Now, here, in none of the writ petitions, my lord, they have produced any materials which is contrary to this, my lord, chitha. Now, this is a revenue record. This is, my lord, a public document. So, they will have to produce materials which would prove contrary to this one. Now, there is a legal presumption, my lord, that this public document has to be taken on its face value and it is to be treated as true, unless and until the contrary is proved. Now, there is no contrary materials, my lord. Then, my lord, lordship will kindly see the next page, my lord, Annexure F, page 120. This is the minutes of meeting which has been heavily harped upon, my lord, by the writ petitioners. Lordship will kindly see what is the content and tenor of the minutes of meeting. They say, my lord, that dung number 97 do not find a place here. Now, and my lord, this Annexure F, the foundation is stated, my lord, in paragraph 10 of my affidavit. Paragraph 10. If I may read paragraph 10, my lord, then I will be drawing my lord's attention to this page, my lord. Paragraph 10, lordship will find it at page 102 of that same affidavit. Why we have, my lord, annexed this document? That with regard to the statements made in paragraph 13 of the writ petition, the deponent begs to state that the settlement proposal of the petitioner was rejected, stating in the speaking order that the disputed government land has been reserved for TB hospital and the applicant is in unauthorized possession of the land. As such, the district commissioner has not violated any provision of law. The deponent further begs to state that the meeting of the SGLSC held on 19/2/22 took a decision of allotment of land for the second medical college in Guwahati, which includes the land allotted to TB hospital along with other land. Subsequently, by notification number so-and-so issued by Commissioner and Secretary so-and-so, the second medical college in Guwahati has been named as Pragjotispur Medical College. Therefore, my lord, lordship will not find the mention of tag number 97. Otherwise, it is our consistent stand, my lord, that tag number 97 supported with the chitha, that is a public document record, my lord, revenue record, basic revenue record, that Dock number 97 is reserved for TB hospital. Dock number 97 is a government land, and that government land is reserved for TB hospital. And if I may read, my lord, Annexure F, my lord, at page 120, that minutes of the SDLSC meeting. My lord, what were the resolutions adopted, my lord? Page 120, my lord. The members of the meeting discuss about the urgent need of a second medical college for better health and accessibility of the general public of the state. The nomenclature of the land of TB hospital to be changed in the name of second medical college. Allotment of proposal of land measuring so-and-so, Dock number 90 so-and-so is approved special report subject to acquiring fences for animal husbandry and veterinary department. So Dock number 90 is with regard to some other, my lord, animal husband. Then allotment proposal of government dock of government land measuring 12 by so-and-so covered by Dock number 98 of village so-and-so is hereby approved. It is for some other purpose. Allotment proposal of land measuring so-and-so covered by Dock number 257 is approved subject to acquiring NOC from the animal husbandry and veterinary department. So this has got only with regard to the fact that, my lord, the TB nomenclature of TB hospital has been changed to the second medical college. This is what has been, my lord, as serial number 2 was resolved. The decision was taken in the SDLSC meeting. So naturally, my lord, Dock number 97, since the entire plot of land, Dock number 97 is comprised of government land and it is allotted for TB, reserved for TB hospital. So naturally, my lord, no decision was taken in that regard, and that Dock number 97 do not find any place in that document, my lord. Then lordship will kindly see, my lord, the next page. This is the last page of my affidavit, my lord.
One
121, my lord, I'm so obliged. But this is a notification. The governor of Assam, this is dated 11 March 2022. The governor of Assam is pleased to name the second medical college in Guwahati as the Pragjyotispur Medical College, Guwahati, in Gopinath Nagar, AK Azad Road, Birubari. So in my respectful submission, my lord, the chain of events, the flow of events inevitably, my lord, suggests without any, my lord, demur, that, my lord, Dock number 97 is a government land comprising of an area of 34 and odd bighas, and that government land is reserved for TB hospital. And, my lord, subsequently, the nomenclature of TB hospital has been changed to the second medical college, which again has been changed to, my lord, Pragjyotispur Medical College. So this is a chain of events. This is a genealogy, my lord, which is flowing from the record. Then lordship will kindly see, my lord, lordship will kindly see, my lord, paragraph 14 of that affidavit, my lord, at page 103. Paragraph 14, my lord, at page 103. With regard to the statement, I am back to state that the land policy of 1989 has been replaced by the land policy released by the government of Assam in the year 2019. Even upon consideration of the clauses mentioned in the land policy 1989, the petitioner is not eligible and eviction of his enclosed land is justified according to clause 14.8, read with clause 15.1 of the land policy of 1989. Because they have raised an argument, my lord, that if not under 2019, then under 1989, they would be entitled. Now, 89 land policy clause 14.8 stipulates, my lord, we have written it, my lord, here. Suitable government land in Guwahati municipal area and in other towns may be kept reserved and free from encroachment for construction of government offices, building, institution, etc. and for other public purposes. And clause 15.1 stipulates that encroachers on government land, including reserve land and land acquired under various land ceiling acts, who are not eligible to get settlement of land as per land policy, shall be evicted expeditiously. So these are the provisions of law. Then lordship will kindly, my lord, peruse the consolidated affidavit that has been filed, my lord. That starts, my lord, from page 135 onwards. Lordship, I will be reading, my lord, from paragraph 3, my lord. This additional consolidated affidavit has been passed in pursuance of order passed by my lord, my lord.
Yes.
There is order dated 29/7/25. From paragraph 3, my lord, I am reading, my lord. The deponent humbly begs to state that in respect of settlement proposals of Sri Arun Kumar Singh, Srimati Sahil Devi, and Sri Sunil Razak, though through an official letter issued from Office of the District Commissioner dated 1/4/25 was forwarded to the Revenue and DDM Department for perusal of the proposal once again, as the same got erroneously approved in the SDLSC meeting held on 11/12/2020, and the same got subsequent approval from Revenue and DM Department, overlooking the fact that the government doc number 97, village so-and-so, was reserved for TB Hospital, a public entity, thereby restricting the settlement proposals in favor of Arun Kumar Singh, Srimati Sahil Devi, and Sunil Razak. So that stage has not yet, my lord, culminated. So midway, my lord, we found, my lord, that error was detected, and immediately we have swung to action, and therefore we are now holding back, my lord. Then paragraph 4. The deponent begs to submit in respect of settlement proposal of Srimati Hamida Khatun and Firoza Begum through an official letter was forwarded to the DM Department for cancellation of the respective resolutions passed in SDLSC meeting dated 11/12/2020 in favor of Srimati Hamida Khatun and Firoza Begum along with other persons. And the same got erroneously approved in the SDLSC meeting held on 11/12/2020, overlooking the fact that the government doc number 97 of village so-and-so under Guwahati Revenue Circle was reserved for TB Hospital, a public entity, thereby restricting the settlement proposals in favor of Hamida Khatun and Srimati Firoza Begum. It is pertinent to mention herein that the settlement proposals of Hamida Khatun and Firoza Begum was not approved in the Revenue and DM Department, as in the case of Arun Kumar Singh, Srimati Sahil Devi, and Sunil Razak. So these are the distinctions, my lord. For some, my lord, government has granted approval, some were hold up in the midway, and for those two persons, my lord, Bankim Biswas and Madan Biswas, my lord, it has already been, my lord, settled. Now, once it is settled, my lord, they attain the status of a settlement holder. Maybe wrongly, my lord, maybe wrongly. But we have to acquire it, my lord. And that the fact that those were done erroneously, my lord, has been clearly spelled out on oath in my affidavit, my lord. Then, my lord, paragraph 5, my lord, we have annexed that order, my lord, wherein no mandamus per se was issued by this honorable court. So it was absolutely misconstrued, my lord, by the revenue authorities in the district level. Then paragraph 6, lordship has seen, my lord, that where we have stated, my lord, that a settlement proposal has been SDLSC in compliance of so-and-so, it was erroneously noted. Then same is with the condition, my lord, at paragraph 7, my lord. One is with regard to Madan Mohan Biswas, one is with regard to Bankim Chandra Biswas. Lordship has seen, I am not repeating, my lord. Now, lordship will kindly see, my lord, page 144, that is annexure 1 of that consolidated affidavit.
Yes.
We have detected the error and we are now seeking to clarify, my lord, rectify it. In all other cases, my lord, save and accept, my lord, these two gentlemen called Biswas, who have already been granted settlement and they have attained the status of a settlement holder, my lord. Others, my lord, we are holding it back. It is not that, my lord, that the government has slept over the matter, or, my lord, the government have waived their, my lord, restrictions and rights in favor of the petitioner. So in my humble submission, my lord, at this stage, the principles of waiver, estoppel, acquiescence, as has been harped upon, my lord, directly or indirectly in their submissions by the petitioners, will not apply in the present case. Since on record, my lord, we are stating here, my lord, and demonstrated with materials, my lord, that we are not going ahead, my lord, with the settlement proposals. When we have realized, my lord, that this DAG number 97 covering 34 bigas is reserved for TB Hospital, it still retains the character of a government land, and it is reserved for TB Hospital, later on changed to Second Medical College, subsequently again later on changed to, my lord, Pragyotispo Medical College and Hospital. This is the flow of events. Here, lordship will kindly see, my lord, this is a letter dated 1/4/2025. Immediately having, my lord, detected the error, this letter has been sought, my lord, from the Office of the District Commissioner to the government for holding back, my lord, this cancellation, for recommending cancellation of the settlement proposals of Arun Singh and others. Because they have deposited, my lord. It had gone to that extent, my lord, that they have deposited the premium amount and it was almost about to be settled. Because under the Land and Revenue Regulation, my lord, 1881, my lord, once a land is settled, my lord, it is a dangerous proposition, my lord. Once a land is settled, my lord, my hands will be tied. He attains the status of it, then I will have to acquire. And this is our instruction at this moment, my lord. In respect of those two persons who have been wrongfully settled, we have to acquire it, my lord. Because they have attained the status of a patadar, my lord. And this, or 7 except those two gentlemen called Biswas, my lord, others have not yet attained the status of a settlement holder. Then, my lord, page 145, my lord, one another person, my lord, the Raskishore Purbe and 4 others. They are also writ petitioners here in my lord, in this batch of writ petitions. Their settlement proposals have also been thought to be cancelled now. Then, my lord, page 146 to 155 is the, my lord, judgment of order of this honorable court, my lord. There is order dated 10/6/2020. Lordship will kindly mark the date of the order. It is dated 10/6/2020. But in that letter, there's 2 letters we Lordship will find at page 156 and 157. For a moment, my lord. Lordship, kindly see in what a hurried manner and in what a haste manner, my lord, it has been stated at serial number 11, page 156, my lord. For a moment, serial number 11 down below. The proposal has been approved by the SGLSC in compliance of Honorable Guwahati High Court's Order 10/1/2020. Kindly say, my lord, 10/1. They were in an absolute hurry. Something is, my lord, I will not put it, my lord, in that way. Something is there. Hurriedly, very hurriedly, it has been done. Very hurriedly, in respect of these 2 persons. When, my lord, this Banking Biswas was not even a writ petitioner in that writ petition. Was not even a writ petitioner. Only these 2 persons, Banking Biswas and Madan Chandra Biswas, both are brothers with a common trait of, my lord, son of Bateswar Biswas. Only with regard to this person, it was done in a, my lord, absolute hurried manner, which is evident from the materials on record. Ex facie evident, my lord. Ex facie evident. There is no such order dated, my lord, 10/1/2020, my lord, which has disposed of the writ petition, my lord. The order by which that writ petition WPC 292 of 2020 was disposed, my lord, is 10/6/2020. So the fact that it was absolutely wrongfully done, my lord, is writ large on the face of the record. Evident, my lord, on the face of the record. This much only I can submit at this moment. And yes, admittedly, my lord, pursuant to this, my lord, we have not taken any action. So far as these letters are concerned, we have detected it recently, my lord, and immediately, my lord, we have swung into action so far as holding back the proposals of those, my lord, whose settlement have gone halfway, my lord. Almost, my lord, to the last point. There we have the opportunity, my lord, to hold them back. But here, water has already flown out, my lord. We cannot pull up that water again, my lord. Because they have already been given the settlement and they have attained the status of a settlement holder. Patadar. So page 156 and 157. So what I understand from the submissions, my lord, forthcoming from the petitioner side, that they are trying to make out a case of negative equality. And negative equality is not permissible. It is not a facet of Article 14. Now, so far as my lord, that other item, Monmill Borough, my lord, that is item number 11. I'd like to draw my lord's attention to the affidavit, my lord, file hearing. Kindly see their statements.
Paragraph? 1 million is 2128.
Yes, my lord, 2128. There, my lord, 8 writ petitioners have joined together. 8 writ petitioners.
No funny anymore.
Their lordship will find, my lord, the statements, my lord, from page 346 onwards, my lord, annexure A. The proceedings are absolutely identical, my lord. Statements have been recorded. All the documents produced by the petitioners or the persons concerned has been duly evaluated, my lord, and finally that decision has been taken. If lordship sees, my lord, Monmill Borough,
Yes.
my lord, page 340, I see Monmill Borough. Yes, my lord, this is the-
244.
Yes,
Page,
my, yeah.
additional affidavit over.
No, my lord, the
Page
page, my lord, 346.
346.
346. That is the only affidavit in opposition, my lord, filed by the state authority.
Statement of Monmill Borough.
Yeah, statement of Monmill Borough. I see Monmill Borough in sound health and with personal knowledge do hereby give statement today on so attending before the Port State Commissioner. I came to Guwahati at the age of 20 years in search of job, and in the year 1992 enclosed a government plot of land measuring 1 kotha, so and so. And the Assamese version, if I read, my lord, lordship will find that at page 348. মই 20 বছৰ বয়সতে গুৱাহাটীলৈ কাম বিচাৰি আহিছিলো আৰু 1992 চনত উলুবাৰী মৌজাৰ উলুবাৰী গাঁৱৰ 97 নম্বৰ বৰ্তমান 12 পুৰণা দাগত 1 কঠা 2 লেছে চৰকাৰী খালী জমি পাই দখল কৰিছিলো. So he has encroached. Then Santi Devi, same statement, my lord, encroached, দখল কৰিছিলো. Without any authority, my lord. Yes, they are at the very inception, whether their entry into the plot of land, my lord, covered by lag number 97, whether it is, my lord, supported by the parameters of law, that I will, my lord, draw my lord's attention to the provisions of the rules, my lord. Because the very entry has to be seen, my lord. If the entry itself is null and void, my lord, their subsequent occupation of however prolonged period it may be, my lord, will be of no aid. Then Sobhit Purbe, my lord, 353. Same is the case, my lord, with all the writ petitions, my lord, but I am drawing my lord's attention to these two writ petitions because it has been heavily harped upon, my lord. I see Sobhit Purbe in sound health, so and so, so and so. Before that, although my paternal house is at Bihar, lordship will kindly see, is at Bihar, page 353. I came to Assam 31 years ago from there and have settled in Guwahati. After coming there, here I started to do small works. I was very poor, so I found it difficult to stay, and I did not have enough means to buy a Miadi land. So I had enclosed a plot of land. They have signed it, my lord. Page 355 is the vernacular recorded, and at the right hand top side, lordship will kindly see in Hindi, they have signed. Everybody, they cannot now say, my lord, that they were not being sufficiently heard. বৰ্তমান বিবাদিত জমি অৰ্থাৎ নৈমান মিলাচা জমি দখল কৰি তাতে ঘৰ সাজি আছো। So everybody have encroached. Page 357, Lordship will kindly see, page 357. Suman Devi, I see Moti Suman Devi. She have also encroached. At the very first paragraph, my lord, the last 4 lines from below, my lord, first paragraph. So we have encroached. Everybody have encroached. They are originally, my lord, from Bihar, Uttar Pradesh. Suman Devi is from Uttar Pradesh. Then Lordship will kindly see, my lord, Lolit Kamat, page 361.
Okay, similar.
Similar, Bihar. All are similar. Then, my lord, page 374, my lord, with regard to Monmil Borough, how we have, my lord, having, that is the report, my lord, of the Co-District Commissioner, having taken the hearing, having evaluated all the materials available on record, whatever has been, because the burden was on them. This court has, my lord, directed the petitioners to produce whatever was available with them. And so everything has been, my lord, evaluated. Then, my lord, page 376, these are the, my lord, Co-District Commissioner's report with respect to, my lord, Lordship will kindly consider for each and every individual lead petitioner, my lord, hearing had taken place. They were given ample opportunity, my lord, and they were heard in detail. And Co-District Commissioner has prepared and submitted individual report for each and every individual lead petitioner here in, my lord, before the District Commissioner. And the District Commissioner in turn thereof, my lord, have passed, my lord, individual speaking order pertaining to each and every individual lead petitioners. So we have gone to that extent. Then here also similarly at page 391, my lord, that eviction notice without giving them a reading period of further 30 days, that eviction notice dated 11/4 was issued, which has been recalled. 391. For all the writ petitioners here, my lord, in this writ petition particular. And everybody have, my lord, received that notice, my lord. In all the subsequent pages, my lord, we have given the note of the Jari Karak. বিচাৰপতি ইমান তাৰিখে জামিন জাননী দ্বাৰাই জাননী চহী কৰি দিছে। So everybody has received it. We have brought everything on record, whatever is available with us. There is no hide and seek. Then similarly, my lord, that Chitha has been annexed, and Lordship will kindly mark one aspect of the matter. In each and every writ petition, we have filed individual affidavits, my lord, for each and every writ petitioners, detailing therein all the statements, my lord, having been made, recorded, all the, my lord, the Co-District Commissioner's report, all the speaking orders have been, my lord, annexed thereto. So they cannot say, my lord, that something is left out from our end. For each and every writ petitioner. Because this honorable court has directed us that you have to give individual hearing. So therefore, my lord, we have given them individual hearing. So they cannot, my lord, in my respectful submission, they are now stopped from raising the plea of violation of the principles of natural justice. Unless and until, my lord, they can prove anything to the contrary. Like they have failed to prove anything to the contrary against that public document, that is the Chitha. And the legal presumption is that it is to be taken to be true. It has to be read in the face below, unless and until the contrary is true. Because it is a public document. Court can take judicial notice. The Lordship will kindly see, my lord, the rules, my lord, the settlement rules, my lord. That rule 18, and before that, my lord, I'll be drawing my lord's attention, my lord. Yes. My lord, rule 15 and rule 16. Before going to rule 18, my lord.
Yes.
Rule 15, settlement of occupied lands not included in any lease. No persons, now here it is similar to us, my lord. It is not a lease, my lord. No person shall have any right to settlement merely because he is in occupation of land not included in any lease granted by the state government, either to himself or to any other person. So even if such provision is not there in the land policy, or there are similar provisions which I have drawn my lord's attention just now, my lord, that there are provisions in the land policy of similar nature. Otherwise, the statute provides it. Rule 15, the statute provides for treating, my lord, how settlement is to be made. Then rule 16, this is of paramount importance. Prohibition to enter into land until issue of lease. Lease shall be issued on written application only, and no person shall enter into possession of wasteland in any area. Wasteland means land, government land, government trust land, in any area until a lease has been issued to him, or otherwise a written permission by Deputy Commissioner has been granted to him, pending issue of such lease to enter into possession. So there has to be at least, my lord, if I am a person, I want to enter into a government plot of land and I want to possess it, I will have to have a, my lord, lease. That is, my lord, the settlement. That is the patta. Or till issuance of that patta, for that interim period, there has to be a written authority from the district commissioner, deputy commissioner, which is absolutely not the case of the writ petitioners here. Now, definition of wasteland lordship will find, my lord, at rule 1, my lord, clause B of that rules, my lord. Same book, my lord. B, lordship got it, my lord. Wasteland means land at the disposal of the government, which the government has not disposed of by lease, grant or otherwise, and which is not included in a forest reserve or in a forest proposed to be reserved under section 5 of the Assam Forest Regulation, or in a protected forest constituted under the rules made under the said regulation, and shall not be allotted as grazing ground under the rules framed under section 13 of the Assam Land and Revenue Regulation. So wasteland finds a mention, my lord, in, my lord, rule 16. So admittedly, that is pure government land. And here, my lord, the Chitha inevitably projects, my lord, that Dag number 97 is a government land, albeit it is reserved, my lord, for PB hospital. That much. And coming to rule 18, my lord. Coming to rule 18, my lord, that ejectment, rule 18.2. I am reading from 18.1. Subject is hereinafter provided the deputy commissioner may eject any person from land over which no person has acquired the rights of a proprietor, landholder, or settlement holder. So petitioners are neither proprietor, nor landholder, nor settlement holder. When such person has entered into possession of government trust land or wasteland or estate over which no person has acquired the right of a proprietor, landholder, or settlement holder, or any land that has previously been reserved for roads or roadside land, or for grazing of village cattle, or for other public purpose. Lordship will kindly mark this, or for other public purpose. Now this, the reservation of government land under Dag number 97 for TB hospital comes within the ambit of other public purpose, or has entered into possession of land from which he has been excluded by general or special orders, and when further there is no bona fide claim of right involved, he may be ejected or ordered to vacate the land forthwith, and the deputy commissioner may sell, confiscate, destroy any crop or building or other construction erected without authority on the land. Now, this has been interpreted in Salakuddin to mean, my lord, that we cannot forthwith go and eject, my lord. We have to give them a so cause hearing. That has been done, my lord. So this is my humble submission. And my lord, one condition precedent, my lord, that one submission was forthcoming from their side, my lord, that they are ready to move out, provided, my lord, that we accommodate them in some alternative place, my lord. Now, for seeking that accommodation, my lord, they will have to justify, my lord, that they are absolutely landless. No statement is there in none of the writ petition that any of the writ petitioner is a landless person. I do not find.
Not plain.
They will have to prove, my lord.
Conrad Mataji. Where was it?
Because Lordship will kindly see, my lord, the on record we have stated that the occupation began, my lord, at prior point of time in the year 1991, 92, 93 onwards. Now, my lord, can anyone perceive a situation, my lord, that till 1993, prior to 1993, if my lord, on 1993, my lord, I am a person, I can come into occupation, I encroach upon a government land, claiming that I am landless. Can it be the situation, my lord, that after independence, till from 1947 till 1993, my lord, can my predecessors would become landless, my lord? That is one aspect of the matter. It may be such, my lord, that there is a flow of, my lord, rural population to the urban areas.
We
my
are
lord.
just randomly checking WPC 2128.
My lord,
Where is there any statement of being landless?
Lord, I do not find prima
Yes.
facie. I will have to check again, my lord.
It's 21. There are 30. That one person on the gallery.
21. 21.
There are.
There is-
21.
That is a submission,
35.
page 35.
Where is your statement?
It's fine. If you didn't reply, I said in mail.
Which case?
Case man,
Which case?
456.
Which case?
Morning government.
4?
This is. There are 30. Last but 3 line, my lord, page 436. The deponent father says that they are landless people clearly belong to weaker section of the society. If they are protected from the plot of land, the petitioner can footpath dweller. So the petitioner pays to settle the acquisition land.
36.
There are 30.
Tara?
There are 13, 436. Right. It was filed on my 16/7/2025. Well, similar.
Yes. Okay.
In item number 24 also, your lordship,
Okay.
paragraph 2, a statement has been made, your lordship.
What has been stated? Please read.
Paragraph 2, it is needless to mention here in the, it is needless to mention here in that neither the petitioner nor his family have any homestead land in their name within the state of Assam. So, I mean, specific ever mean, your lordship.
Okay, we'll conclude this.
Now,
This one, my lord, some false statement has been given before the honorable question. I have to show before your lordship, my lord. Because making he is harping for the my lord, I have to counting for 12 times. What statement he has stated, my lord, I have categorically stated, I reply from this one. they, first I file a representation, Monmil Boro, I have shown. He has that setting nothing in speaking order as well as report. When we go to the hearing, nothing took place, madam. They took signature in blank paper. I have categorically stated in my affidavit in reply, they took the signature on blank paper, my lord, and they has write whatever they like. Even it is, my lord, what they have writing here, that I have a land in ancestral property, that false statement in the, my lord, speaking order also stated that he has an ancestral on reports, ancestral property, there is a land, my lord. This type of statement, I want to say, my lord, he said, I cannot do anything for Madan Biswas and Besar. He himself and other say, when initial entry is illegal, everything is illegal. If it is illegally, patta has been given, my lord. My humble submission before you also, what step has been taken to cancel the patta? Because if the initial entry is illegal, an important thing is that, my lord. Lordship kindly come to the Biswas case, my lord. In their affidavit in opposition filing Tukumuni Hazarika, consolidated affidavit, 1/4/2025, they have taken the decision to cancel the patta of Arun Kumar Biswas and Ada. That affidavit was filed by the one circular of the Raja Boisho. In my case, my lord, before that affidavit has been filed, not a single word has been uttered that they are going to, they cancel this, all this document. When the hearing, it has been crop up, they come to the another stand that this is a erroneous decision. I want to say, my lord, they do not want to produce the original record along with all the statement that land has been, my lord, reserved for TB hospital, my lord.
It is
Because, my lord, everything will become, my lord. And they saw to the drawing that how can, my lord, Madan Biswas, my lord, settlement has been given. My stand till today, my lord, 19/7 DAG is not available, and that is why they have settled with the Madan Mohan Biswas, my lord, and Bankim Chandra Biswas, my lord. My stand is still there, and that is why we are on same footing, my lord. And we have stated in our representation, correct fact, we are 30 to 35 years on that land, my lord.
Where is
And
that statement that you're in the pleadings that you did not make any statement, it was blank paper you were made to sign?
yeah, my lord, when
Well-
the affidavit filed, we came to know all these things. In my reply, page 4, my lord, I am reading.
429.
428, my lord.
428.
Yes, my lord.
Hmm.
That as regard to the statement made in paragraph 4, affidavit is incorrect, baseless, misconception. The deposited they are in the plot of land so and so within the land policy. The deponent had stated that the writ petitioner 01 schedule, the writ petitioner number 2 so and so are living there. The petitioner further states that already settled the land Arun Kumar Singh periodic patta has been issued. So and so categorically stated therefore land. The deponent further that all writ petitioners were forced to put the signature in a blank paper, and the statement which has been annexed to the writ petition authority has been written by them. So the deponent denies the authenticity of the correctness of the statement of the affidavit in opposition. And your lordship kindly look to that statement, my lord. If your lordship go to the statement of the Monmil Kumar Boro, Shanti Devi, this is one person handwriting, my lord. Everything has been written down by one person, my lord. And in speaking order, I file a representation that immediately after my 7 days. What is the reflection in the speaking order in respect of that representation? Nothing is
But
there.
statement, while recording it can be done by an authority. Handwriting, how will it make a difference? Statement, you are not required to put on your own. You have given your representation.
My lord,
Representation will be your handwriting or,
represent
but statement can be taken by somebody.
my humble submission report, my lord. Why the police officer's statement was not considered under 161 statement, my lord? My lord, my humble submission.
This is not a police officer
Yes,
taking
my
a
lord.
statement.
Yes, my lord.
Do not require 161 with this.
Yes, my lord.
This
They
is a
have-
statement recorded when you had gone for the hearing.
Yes, my lord. My humble submission, they have taken signature in blank paper, my lord.
Have you stated in the writ petition?
When affidavit has
No, 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 no. In the writ petition, your statement was already, your signature was already taken in blank paper.
My lord, I
In the
do
writ petition, did you make a mention?
I reply I mentioned.
No, not in the reply. That will not do.
My lord, in reply I have
In
stated.
the writ petition, you could have stated that our signature was also taken in blank paper. We do not know how those were used.
My lord, in my, what is available, that is I submit,
No.
my lord. Yes, my lord. And another thing is that, my lord, I am one thing, 1/4/2025, when my lord Raja Boisya has filed the affidavit, my lord, why he has not taken all these things, Madan Boisya cancelled and other. It was submitted last time when the hearing took
Sir,
place.
we'll
then-
take care of Modern.
Yes, my lord.
Modern and Bonki, we'll
Yes.
take care of this. Okay.
My lord, you know, she kindly go to the affidavit, both the affidavits
Yes,
will come. Nothing, they are silent about this, what he is submitting before.
Yes.
With one, only one last submission, my lord. The lordship will be examining the decision-making process. Now here, before the authority, there is no statement that they are landless person. That is, let them show, before the authority. This, here, nothing. When their statements were recorded. If I read Monmil Bolo, Santi Devi, the fact that they are landless, it is not there. That much.
And my lord, in respect of my lord Sitha, your lord, kindly original Sitha along with Mondal.
No, we have a team, my lord, waiting outside, my lord. If lordship wants to pay, they want to pay, inspect, my lord, we can bring it.
Third sequence, huh? Saburnam. This will be in item numbers. Except 5, 6, 7, 8, 9, 10, 16 and 17. Already such a order passes. Take a body, huh? Hard friends, huh? Also heard 3 R. Borpazir, Leonard Standing Council Revenue Departments, and Sri S.R. Borwa, Leonard State Council. Sri Borpujari has also submitted that the original records are ready, which can be inspected. Better. Hearing is concluded, judgment is reserved. We'll consider. Yeah, ask.
I'm so obliged.
Please give the number, Mr. Deori. Yes, you are supposed to give the number. And Mr. Dhor, your petition, and Mr. Chaudhary, please, your petition. Oh.
I'm obliged.
এখানে ঠাই বলে এখানে বহুত নামাৰিব এটা মাৰিব বাৰত
In this matter, the petitioner was supposed to file the counter affidavit.
petitioner was for
32, my lord.
so he may be undergoing to rejoinder. Please for the petitioner.
My lord, we'll also be filing our affidavit. It has gone for the vetting, my lord.
You have filed affidavit, Mr. Das?
We'll file, my lord. It has gone for vetting, my lord. Can it be up to 2 weeks, my lord? It's a 25 matter, my lord.
Okay. And you have filed affidavit, private respondent. What is your name?
K. Kashyap.
K. Kolita.
K. Kashyap.
K. Kashyap.
Lordship.
While the private respondent number 4,
Correct.
represented by Sri K. Kashyap Learned Council, has filed the affidavit in opposition, the state respondents represented by Sri H. Sharma, Learned Additional Senior Government Advocate, has submitted that the affidavit in opposition has been sent for vetting,
Right.
has been prepared and sent for vetting and will be filed shortly. Correct? In view of the aforesaid submission, the matter is adjourned by 2 weeks to enable filing of, to enable further exchange of affidavits.
Date में
What is the matter?
Lordship,
Matter regarding what?
Lordship, the company. Actually, the letter is Lordship. And I had filed this petition of.
Yes, over there.
Sitting at before the law.
Is there any interim order?
No, Lordship.
Yeah. Only 2 weeks.
Lordship.
Next.
Madam, what is showing?
We have taken steps regarding respondent number 6.
17
I have
matter, yes,
appeared
yes.
for-
Mr. Mohanta was making a mention. What is it about? Right, council has submitted the is not consider the photo. Yes, Mr. Morali.
Lordship, today I have appeared for private respondent 6 and 7. Today only I have filed a Wakalatnama. Lordship,
What is the matter about?
Lordship, it's a allegation by the petitioner as regards some construction taken up by the private respondent number 6 and 7 over a disputed land. But facts remains, Lordship, in between these parties, Lordship, several civil litigations are pending. These are still going on since 2017. And in one,
Negative pin beside it. I couldn't manage the negative pin. Let the pin can I heal. Just a minute.
Now, Lordship, in between the parties, several civil cases are pending in the court of civil just senior division 1, then senior division number 2, and senior division number 3 also before in Guwahati
Okay.
with regard to this disputed land. And 4 cases we have filed, the respondent 6 and 7 for specific performance of contract based upon the agreement, registered agreement executed in favor of the executed by the landowners in favor of this private respondent. Now, in those matters, Lordship, restrainment order has been passed, and we have given, Your Honor, our undertaking also in written manner that there is no construction as such, even then, Your Honor, and that has been admitted in the writ petition itself. Now, because of that, Lordship, so far maintainability of this writ petition is concerned, it is kept open, Your Honor. White order dated.
So what do you propose? Will you file affidavit here? But it's a matter of 17. You have entered appearance today. It's
Lordship,
okay.
day before yesterday, Your Honor, Lordship, yesterday evening I have received this copy.
Okay.
So today only I filed.
No, we'll definitely grant you time. You're appearing for the first time. But
Lordship.
17 matter, we can grant you 2 weeks time.
Lordship.
You'll have to file it within 2 weeks.
That will
Okay.
be.
Madam, your name is not there? Heard Miss So-and-so Leonard Council appearing on inspection of Sri M. Mohanta for the petitioner. Para? Do the case which is pending since the year 2017, was at a stage of ascertaining whether respondent number 6 and 7 have been served, Sri N. Bhorali, Learned Counsel, has submitted that he has entered appearance on behalf of the said respondent number 6 and 7. Full stop. He prays for and is granted 2 weeks time. He granted 2 weeks time to file the affidavit in opposition. Also heard Sri Nayak for Learned Counsel for the GMC.
1 to 5, Lord, with GMC, GMD.
GMC, GMD. But at least after 2 weeks.
Let. Well, here, well, the petitioner then, so that has been made government then wrongly, my lord. Your losses may come to page 16A, my lord. Annexure 1.
A. 16A.
Annexure 1. Well, this is that application in 1978, my lord, when they came to know, my lord, that this land has been made cast. I beg to lay the following. Originally, I am the owner of grant number 102 by 136, 34 by 40 of Gava Moja, comprising of 730 bighas so and so and so and so. That in the last survey it was found that 816 bigha lechards are missing and only 179 was found to be in my possession. Now on scrutiny, only 86 bigha land has been registered in our favor. Some of the darks of the new lease grant number 1 to 93 bigha 2 katha 3 lechards has been shown as Sarkari by mistake in your office. These 93 bigha 2 katha lechards are already under plantation. That in support of the above mentioned so and so, I am attaching here the 2 copies of the DC Nagaon, Morigaon and Escalon for your re-reference. Now, my lord, if your losses will see the note, my lord, which is at page 18, my lord. In Assamese, my lord, my lord, that has not been.
Page 18.
18, my lord, the notes, my lord.
Yes.
My lord. This is number Aru, sub-deputy collector order City Hukum Mate, Echo Sui Soitis newly grantor, Echo Teis number Dagor, Siaki Biga, Mati Bade, Baki, Mati, so and so. Tianmo Biga Lusa, Sorgari Kohoy. No any reason, my lord. Well, why it has been done, Sarkari, there is no reason. Now, my lord, the Deputy Commissioner wrote a letter to Commissioner that the land is under plantation, so it should be given to them, settled with them. But in reply to that, my lord, the government has written a letter, page 21, my lord. Page 21. With reference to above, I am directed to say, it seems that a case for restoration of 93 bigha 2 katha land which the Gopal Krishna Tea Estate has purchased in 1963 and has been in continuous possession under the actually the tea. The circumstances under which the area was made Sarkari are not those and not adequately explained in your report. However, the garden authorities may kindly be directed to produce the purchase document, if any, in respect of the land in question, and then you may submit the same to a government after further inquiry for consideration of the government. So this is the matter. Then, my lord, another letter, my lord, additional deputy commissioner, my lord, at page 22. on the above noted subject, I am to say that the copy of the CETA enclosed a total area of 93 bigha 8 acre land belonging to Gopal Krishna Tea Estate was made circular by the then settlement officer by this order number so and so, but no reason for so doing appeared to have been recorded as per the copy of the CETA. The Tea Estate Authority have prayed before the government for restoration of the area made circular to the lease, and government has now wanted to know the reason for making the land circular. Since the reason for this was not mentioned in the CETA, we are not in a position to apply the government about it unless a copy of the so-and-so order is made available to us. I therefore request you kindly to furnish so. Hello, this is that. Now, next, my lord, page 23, which refers to a letter mentioned, I have not to inform you that settlement officer order by the then settlement officer at Nagaon district is not traceable in our records. This is for your information. Then, my lord, we have written letter, my lord, to them. Yes, letter. Now, my lord, at page 28, the interim letter has been issued. To the manager Gopal Krishna, with reference to the subject above, I would like to inform you that the following schedule of government land under Kuthuri Bagicha Kisan will be demarcated on so and so. As per below mentioned, scheduled government land is adjacent to your tea estate. So you are requested to present during the time of demarcation. It needs attention that encroachment of this land will be cleared on 23/12/25. Out of this, my lord, entire land except dark number 187, that was government land, my lord. The rest area, my lord, this is my purchased land in Gopal Krishna, and these are made wrongly circulated. So for 187, my lord, 10 bigha, 5 licha, that is government land. I have nothing to say, my lord, for that. For that, I have mentioned, my lord, that I shall give exchange of the land. So, my lord, this is the position, my lord, here. So for 10 bigha is concerned, my lord, I am giving some other land, but because it is within the garden and tea bushes are there. So, by the side of the garden, I am giving another land for that exchange. In that respect, my lord, I have filed an affidavit also. Subsequently, because earlier plot, my lord, they said that this is not a cultivable land. So we have given a affidavit of 9/5/25, my lord. There we have mentioned, my lord, that so far this is concerned, we are giving another land, which is cultivable. That your lordship may see, my lord, the affidavit filed by us, my lord, at page 50, my lord. My lord, 2, my lord. I say that which I prefer the instant definition among other so and so. Next, I say that Krishna has been operating the tea estate under the name of Gopal Krishna Tea Estate since the year 1960 at Killing Valley, having a total area of 425 acres known as Kuthuri Bagicha. Krishna Company purchased the aforesaid land garden from Menoka Tea Estate Private Limited by executing registered deed dated 10/166, and since the time Krishna Company has been in continuous possession of the land. I crave the leave of Sonukor to produce the the indenture dated 10/166 at the time of hearing. I said as soon as without considering the aforesaid aspect of the matter, unilaterally without giving any opportunity to the petitioner of being heard, declare an area of so and so land as government. Pertinent to mention herein that earlier the said plot of land was mutated in the name of the petitioner company, fact of which is clearly evident from the Jamabandi of the land. It pertinent to mention herein that no rhyme or reason has been assigned as to why the aforesaid land has been converted to government land by the Assam authorities. Pertinent to mention that a perusal of the map of the portion of the garden which has been annexed in the eastern additional attribute, the areas which has been marked with red strips are the plots which have been illegally converted to government land by the Assam authorities, which are almost coming within the middle of the garden. If the aforesaid converted garden, entire structure of the garden may be disturbed, and the same shall cause serious prejudice to the petitioner. The extra 10 bigha land in respect of dark number 187 will be given by the petitioner from the land shown in the blue line, given the map of vacant land, which is a vacant land. So 10 bigha, my lord, we are giving vacant land. Otherwise also, my lord, they should give a hearing, my lord, because the division bench has passed an order, my lord, in such matters, my lord, that They should give a hearing also, my lord, in this matter. Without, my lord, giving any rhyme and reason, my lord, this settlement officer passed an order and converted the 93 bigger land as just a guideline. So, where is the judgment of the, my lord, Justice Borua? And so,
Yes, Mr. Babu.
Yes. My lord, if at all the petitioner is aggrieved against the conversion of the land, my lord, he could have challenged that. That he has not challenged, my lord. During, my lord, during 2015, my lord, the petitioner was asked to submit all relevant documents in respect of his claim of the land in question, but he failed to submit anything, my lord. And as your lordship directed, my lord, we have also, my lord, received the record, my lord. Record says so that this is, my lord, government land now since 1970, my lord. And no appropriate step has petitioner been taken, my lord, for the purpose of rectification or any other, my lord, lawful measures. So, my lord, even if assuming, my lord, that the land was earlier in the name of the tea garden, my lord, but in our
Is there any document next to this petition,
my lord,
regarding the
Claim.
earlier position?
my lord, no,
Because we have just made a rough calculation.
my lord,
The initial, as per projection,
my lord.
around 996 bighas.
Yes. Not
Around
that,
nine-
yes.
Now, is there any supporting document?
Well,
for-
this CLTT is there, my lord. And
No,
this
no.
tag is, my lord, 102, my lord, this,
No, with the writ petition.
my lord, with that petition, my lord, the Jamabandi we have given, my lord, the annexure, my lord, the additional affidavit, Jamabandi is there.
Let us see the
At
Jamabandi.
page 154, my lord.
54.
Right.
দাদা কিহৰ ফটো কিহৰ ফটো
Additional affidavit. Additional affidavit. Additional affidavit.
Area. This Jamabandi total area will be how much around?
My lord, this land, my lord, it is more, but this 93 bigha has been converted to government land. 93 bigha, 2 katha 8 lakh. And on coming to know immediately.
But your initial grievance was that out of the land of around 996 bighas,
Yes.
816 bighas were not in the records.
Well, that fact has been given by my lord. That is not my case now. My case is only in respect of 93 bigha.
93.
And 10 bigha, my lord, so far government land is concerned, my lord, I have nothing to say, my lord, that is a government land, but it is a.
10 out of 93.
No, more than, 103.
103.
Out of 100.
According to our affidavit, my lord, total 103 bigha, 2 katha 13 lessa.
Yes.
That is.
Now, if you come to the
These are government
impugned
land,
order at page, let us come to the impugned order, which.
Yes, page 28.
Page 20, which you want interference.
Yes.
Yes.
My lord, this is
Only a notification, my lord.
My lord,
Particular demarcation and my lord.
This is in 2015, but 1978, my lord, we applied. Since then, the correspondence are going on.
No, but kindly read 28. What is the purpose of this?
With reference to the subject cited above, I would like to inform you that the following schedule of government land under Kutri Kisan will be demarcated on so and so. As the below mentioned scheduled land, government land is adjacent to your tea estate. So you are requested to be present during the time of demarcation. It needs mention that the encroachment on this land will be cleared on 23 to 28. Cleared means it shall be everything.
My lord,
Not 18 to notice, my lord, but this is That type of.
This is the only document, my lord, challenged, my lord, in the present writ petition.
Yes.
That process which my respected senior has cited, my lord, that has not been questioned.
But the last sentence of this, though this notice appears to be innocuous,
My lord.
that it is a demarcation notice.
Yes, demarcation. my
Last
lord,
sentence also states that apart
It-
from demarcating,
Encroachment
encroachment
will-
will be cleared.
Yes, yes.
So even if they are for
It's all right, my
assumed
lord.
to be held as
Yes.
encroachers.
For the timing to stay the issue, my lord, stay the, my lord, this notification, that is all right, my lord. But so far claim of the petitioner.
Yes, yes.
That has not been, that this notification will not cover, my lord. This is my respectful submission. Because as per the affidavit, we have.
So who will do the exercise?
My lord.
Now they are saying that 103 is okay, but so far as 93 because is
Yes.
concerned,
My lord.
they have a right over that 93.
But in our affidavit, we have stated.
No, no, who will do the exercise?
Certainly under the deputy commissioner, my lord.
They have to find out, my lord, how if this land has been met certain.
But one thing will also come up, Mr. Sayola.
Yes.
Though in the demarcation notice, it has been clarified that land found under as encroachers
Yes.
will be cleared or evicted.
Yes.
But how from this, how do you come to a conclusion that you are encroaching government land?
They are saying, my lord, that it's a government land. As mentioned below schedule.
Yes,
government land is.
no, no, which part you said it is wrongly been described as government land?
My lord, this, we refer subject, I'd like to inform you that following schedule of government land.
Yes.
Under
Out of this schedule, which part you say is wrongly stated as government land?
Yes,
Which
as the below mentioned schedule, government land is adjacent to your district, below mentioned government.
And my lord, under,
Yes,
my lord, under DAG number 190, my lord. My lord, maybe there is a big area, but here government land is 9 bigger.
No, no, that is what we have to get you from
Yes.
Mr. Sayola. In the table,
Yes.
there are 1, 2, 3, 4, 5, 6 separate plots, DAGs.
No,
Yes.
no, seven.
1, 2, 3, 4, 5, 6, 7.
Seven.
Out of these, which belongs to you? You claim to be yours.
Except 187, we are claiming all.
Huh?
Except 187, I am claiming all.
Okay. This 10 you are saying that is maybe government.
Yes.
187. Rest 93 should be yours.
Yes. And my lord, finally, you will also see, my lord, government also asks, my lord, how it has been met, Sarkari, my lord.
No, this is an internal
lord,
communication, my
my
lord.
lord.
That is in that will not help the petitioner's case, otherwise.
Lord, after all, the notice they are, my lord, this assistant Sultan of the Jamabandi, they have said, my lord, this land has been met, Sarkari. On what basis? There must be some basis, my lord, they must acquire it, or it must be surplus, something it should be there. How otherwise it can be met government?
Maybe ceiling surplus land, my lord. Maybe.
Maybe.
No, this is a special cultivation, ceiling surplus.
At that time, secrecy was not there, my lord.
77, during 70, I think.
72. It is 72 government, my lord, tea garden applied.
No, special cultivation is excluded.
Excluded, but
Even
the
after
limit is there, my lord.
1956
Special,
Act.
yes, special cultivation is there, my lord, always there, but there is also, my lord, certain things are there, my lord.
There may be other things for
Yes.
which government may take
Yes,
over. All
yes.
this, the government may acquire, government
It's
may.
not that, my lord, unlimited portion
Or
of
it,
land
it,
can
it,
be.
it may not be under cultivation, particular portion.
Yes, my lord. And my lord, some portions of the land, my lord, he has referred to, my lord, that is also not under cultivation, my lord. The portion of the land under cultivation that we have cited, my lord, in our affidavit.
No, Deputy Commissioner, my lord, has said, my lord, it is under cultivation. If you'll also see page 18A, my lord, annexure 2.
Some
Some.
some portion of land
No.
under cultivation, but
18?
some are not.
18A, my lord.
Yes.
My lord, here, my lord, if you'll also see.
Under cultivation, my lord, according
lord,
to
at
our
page
affidavit,
18B.
70 bigas,
Yes.
70
My lord,
bigas, 3 kathas, 18
18B last, but to one paragraph, my lord.
Yes, but the said.
But the said land already under possession of tea state and management of the garden authority is paying their so and so. The garden authority has been paying TV revenue regularly. On the other hand, gets the tea garden from the possession and uprooting the plants will not serve any purpose of the land in question, which is surrounded by tea plantation on all sides. My lord, this, my lord, my grievance is there, my lord, in 78, I made the application. Since then, my lord, it is going on there, correspondence is going on. They should, my lord, consider it. My land, so far 10 bigha is concerned, I have nothing to say, my lord.
This demarcation was done pursuant to the notice of 1512?
No, no,
No, that is
no.
a state
that-
agency.
No, there is no stay as such.
No, it was, my
In
lord,
the interim, the demarcation proposed by enforcement case number so-and-so may be carried out, but the petitioner should not be dispossessed
my lord, not carried out.
from any tea growing land without first considering their offer for giving up equal measure for vacant tea estate land for the proposed move of the government.
It will. My lord, there is
Mr.
no-
Goswami, even that proposal is there. For they are also proposing for exchange of land, which
My lord, that cannot be, my lord, the portion of the land they have, my lord, referred to, my lord, that portion cannot be exchanged in view of the fact that, my lord, this is not a cultivable land, nor, my lord, for the purpose of construction of any, my lord, house. That we have mentioned in our affidavit.
So far 10 bigha is concerned, my lord, I have given the press land, my lord, in the second affidavit. That is a cultivable land. So far 10 bigha is, 10 bigha and it is. My lord, it is under the office of the deputy commissioner, they must verify it. How, my lord, this land has been made surgery. My lord, I have the cell in my lord. Okay.
This one has a proper.
Mr. Goswami, Mr. Goswami,
Hi.
please have a look.
Yes. That are-
102/190, 136 dated 28/7/1933.
Yes. Yes.
But, কি বুলি ক'লা এইটো?
Convert it to government land. বিঘা মাটি ইমান যাতে বাকী কিমান বিঘা ৯৯ মাটি চৰকাৰ হয় তাৰমানে ইটছ এ গভৰ্ণমেণ্ট লেণ্ড চৰকাৰী কৰণ নহয় না চৰকাৰী কৰণ কৰণ
My lord, the page number 55, my lord, of their additional affidavit.
Yes.
As my respected senior has already referred to, my lord. Page, is it 55, isn't it?
Page 55.
69. চিঠি
Yes.
মৰ্মে হুকুম মতে 102/36 নিউ লিজ গ্ৰান্টৰ 123 নম্বৰ দাগৰ 86 বিঘা মাটি বাদে বাকী 168, 161, 158, 190, 186 আৰু 264 দাগৰ এইটো কি টাবত 93 বিঘা 8 লেচা মাটি চৰকাৰ হয় গভৰ্ণমেণ্ট লেণ্ড
Sarkar, why means the Sarkar, this is that's Sarkar.
not converted, my lord. This is not converted, my lord. The Sarkari,
চৰকাৰী কৰণ কৰা
by this order, my lord, there was, my lord, government has not converted, my lord, the land to a government land, my lord. But it's already, it's a government land. my lord.
Oh, yes.
My lord,
That it means, my lord.
that note is, my lord, at page 18, my lord. See. That slightly, my lord, while affording, my lord, there, that is.
The petitioner has referred to, my lord.
My lord, page 18, my lord, your lordship should see. Sarkari kora hoy,
Page 18%.
page 18. Yeah, of the petition.
That which I have, my lord, referred to is a copy of the Sitha, my lord. And this is only a note, my lord.
This is the order on the basis of which in the Chitha they have done it.
I'll try to get it.
In the Jamabandi, they have mentioned it from the order.
How will it make a difference? If your
Yes,
interpretation is.
my lord, the land is already Sorkari method,
That will not be it's
not converted to Sorkari. From private land to Sorkari, that I want to mean.
The Jamabandi name is in my name, my lord. The darks are in my name. Now, what it means? The darks are
You
in
have
my-
the records.
Yes.
Can you check the records, verify the record?
Okay, ready? Come on, slide.
Number 27. Number. You got that, number.
Yes, that order is necessary.
Otherwise, Mr. Goswami, who would be the competent authority to look into the original records and pass and detailed order? It is difficult for this court. First, the documents are not very legible. Number two, it is not complete also. We'll do one thing, we'll have this matter day after tomorrow.
Yes.
We have.
On that day, I'll try to find.
Yes, yes, please find it out. We'll try to, we'll obviously resolve the matter. But not as a primary authority, maybe if we'll send it to somebody.
My lord,
Mr. Sahawala, whom do you
the circle
suggest?
officer, my lord, he can verify, my lord. Under deputy commissioner, my lord. Or settlement officer, my lord. Settlement officer who has passed the order. Settlement officer who has passed the order.
What records do you have, Mr. Pakuti? What records?
Jamabandi and Chika.
Okay, we'll examine this, okay. Day after tomorrow. Thursday.
Even if the portion of the land is converted, my lord, without rhyme and reason, government cannot do so, my lord. Government is not.
Yes. That is the.
No, that is why, my lord. And petition is also not clear, my lord. And petitioner has not challenged me, my lord. Petitioner has challenged only, my lord.
The conversion will have to be preceded by some reasons.
Yes, my
But if the land was already government land, the question of conversion will not arise at all. So
yes, two things are there.
yes, your contention may have some meaning that Sarkar land and Sarkari kora hoy.
And even if the land is converted to government land from the petitioner's, my lord, Miyadip Patta, even in that case also, my lord, appropriate proceeding was certainly there, my lord. And petitioner has not raised the issue, my lord.
But Mr. Sahawala, you are in position right now.
My lord, and once in 1978, my lord, on coming to know immediately, I filed the application. Since then, my lord, correspondence with government. Government also asked, my lord, how.
No, we are due to resolve the issue, my lord. I'll find it out, man. Try to find it out. Who will be the competent authority to look into all these matters?
You immediately correspond, and if on day after tomorrow there is some difficulty, we'll accommodate you, but we'll try to resolve day after tomorrow.
Yes. That is it.
Heard Sri G. N. Sahawala and senior counsel for the petitioner, as well as Sri B. Goswami, learned AAG, Assam, full stop. There. Sri, the learned AAG has prayed for some time to obtain further clarification in the matter, as from the documents made available to the court, comma, there appears to be some lack of clarity as regards the vernacular, as regards the documents which are in vernacular are concerned. Sarah? List day after tomorrow for hearing. Rest may not be possible. Madam, which matters are yours? What is the matter about?
Lordship, this is relating to central excise
Yes.
subsidy matter.
Yes, Mr. Mr. Yurin?
Mr. Kyal is also on leg Lordship.
Okay, when do you have day after tomorrow?
Also,
Oh, 17th matter, oh.
17 matter.
Day after tomorrow. But day after tomorrow, ask Mr. Kal to be here.
Lordship.
All matters will give preference.
Lordship.
Okay?
Lordship, 40, 41 may be deferred.
Huh?
No, one chance even item number 38, that may, Lordship, come up day after tomorrow. 38.
38, this Purvanchal, yes?
Yes, sir.
Day after tomorrow.
There. Much obliged.
Rest will have another day, unless it's extremely urgent.
Much obliged, Your Lordship.